Good morning, everybody. Happy Thursday. Welcome to TCF Live. My name is Dan Soul. I will guide you on a 3-hour journey through Courtlandia, but before we get going, Barbara, thank you for $5 already. Let's hear it for Gigi. I agree. Gigi, we love you. Good to have you with us. Let's get started. Allegan County, Michigan. This is Judge Skocelas.
For sentencing for crime victim rights purposes. Ms. Mancinius, is Amanda Lindahl Lemke present, or she filed an impact statement with your office?
My understanding is that she was going to Zoom in with my victim coordinator, Imelda. We had emailed the court about it yesterday. Has she checked in, Kelly?
What is her name? She didn't tell me her name.
Let me get into my file. I was just backing out to find the
email.
Amanda
Lindahl Lemke.
That's her. Then now. On the Motorola device, can you unmute? Tell me your name, please.
Craig Lyons.
No, she is not here.
I'll tell you what, we'll put her at the bottom of the stack and see if she shows up before the close of our sentencing docket. So who's next?
Shanda King. Mr. Diaz will be back with you shortly.
Next case is file 261239 SD, People versus Shanda and King. Here today for sentencing, originally charged with a charge of operating while intoxicated at a pretrial conference on July 9th. Prosecutor's office reduced that charge to a charge of operating while impaired. In a written pretrial offer, they recommended a sentence of no jail, no probation, fines, and costs only. They also agreed to waive their presence at sentencing. As required, I ordered a substance abuse assessment, which has been completed. So with that, we are able to proceed to sentencing this morning. Ms. King, this is your chance now to tell me anything you would like to for your sentencing.
I don't think I have anything.
Defendant, on behalf of Ms. King for her sentencing.
Thank you, Your Honor. This is the first time Ms. King has ever really had serious court contact before in her life. Frankly, she is embarrassed. She has completed already her victim impact panel. I have her certificate of completion. I will share that with the court and the probation department. She is, I believe, low risk level, and considering her lack of criminal history, I would ask the court follow the recommendation of fines and costs. Thank you.
Review the materials I received for sentencing. Show as your attorney indicates, Ms. King, you have no prior drinking or driving offenses. Blood alcohol content in this case was relatively low. And there is a recommendation in your plea agreement for no jail, no probation, fines, and costs only. And we also have a new statute now that indicates unless there are reasons to place you on probation, there's a presumption you should not receive any probation. Do not find any reason to exceed the presumption in this case, and will follow the recommendation of the plea agreement, impose a sentence of no jail, no probation, fines, and costs only. On the reduced charge of operating while impaired, the fine is $300. Court costs are $400. State costs and fees are $125. There's a $100 fee for the substance abuse assessment done through the court for a total of $925. Court file shows you were released from the Allegan County Jail on a $500 personal recognizance bond, so all of that is due. We'll put this out for payment over the next 90 days. The final requirement would be to complete a victim impact panel. Your attorney has indicated you've already done that. Please provide proof of completion of that back to the court within that same 90-day period. So Ms. King, everything I just said is going to be placed into writing and sent to you in the mail. So you're free to hang up the court proceeding this morning. Be expecting that in the mail. Good luck to you, ma'am. Thank you, Mr. Pendente.
Thank you.
LePan. Nathan LePan, can you hear me? Mr. LePan, can you hear me?
Yes, I can hear you. Sorry about that.
This is file 261282 SM, People versus Nathan John LePan. Here today for sentencing. Was charged in this case through the Allegheny County Prosecutor's Office with a misdemeanor complaint charging domestic violence. At a pretrial conference on July 10th, pursuant to a plea agreement, the defendant entered a plea to that charge. The prosecution recommended a first offense deferral. At that time, they also indicated we needed to adjourn this for crime victim rights purposes. And Ms. Winsemius, is Carrie Cochran present, or she filed an impact statement with your office?
He is not present, Your Honor. At this time, I would just ask that you proceed with the sentencing per the recommendations.
Okay. And the recommendation regarding contact with Ms. Cochran?
I would have no objection to non-assaultive contact, Your Honor.
Mr. LePan, this is your chance to tell me anything you'd like to for sentencing as well.
I don't have anything.
Mr. Goodrich, on behalf of your client for sentencing.
Your Honor, we have Mr. LePan, who's acknowledged and taken responsibility for his actions. He's working on his conduct and understanding himself. I agree with the prosecution that the no contact with the victim should be for non-assaultive contact. Excuse me this morning, Your Honor. And we anticipate him completing the diversion program and having this off his record in a year from starting.
LePan, this is now your third misdemeanor conviction, and within the last 4 years, you have convictions in 2022 for indecent exposure, another conviction in 2022 for operating while impaired, and now here in court on a charge of domestic violence. On this case, though, if you complete the 1-year probation successfully, this case will be dismissed. Probationary period for this deferral is for a period of 1 year. There's a $625 oversight fee attached to that. You will have the entire time on probation to pay that amount on a monthly payment plan set up through the probation department. While on probation, the probation department will have the authority to provide counseling services both for domestic violence and for substance abuse if they believe that's necessary. The no contact provision of your bail is going to be amended to a probation condition of no assaultive or intimidating behavior, which means nothing assaultive with anyone or nothing threatening with anyone. But the bottom line is, as of today, you can have contact with your wife again. Because of your prior conviction for operating while impaired within the last few years, I'm also going to indicate while on this deferral, you not possess or consume any alcohol, marijuana, or illegal controlled substances. They will have the authority to check you for that here at the probation department, have you checked with the police at your home, or have you physically monitored for alcohol consumption at any point while on probation. And Mr. LePan, at this point, the probation department is going to contact you on the telephone to set up that probation order. We'll have you sign it electronically today, so you won't have to come here into the court building. What telephone number can they reach you at today?
269-213.
You are free to hang up from the court proceeding. Be available at the telephone number you just gave us. Probation department will call you at that number and set up your probation order. Again, if you complete the probationary term successfully, next August, my successor judge will send you a letter in the mail saying your case has been dismissed. And good luck to you, sir. I hope that's what happens. Thank you, Mr. Goodrich.
Thank you, Your Honor.
Frank Lyons, can you hear me?
Yes, ma'am, I can hear you.
About 260739 SD, People versus Frank E. Lyons. For sentencing, originally charged in this case with a charge of operating while intoxicated. At a final settlement conference before a jury trial, the prosecutor's office reduced this to a charge of operating while impaired. At that time, they also agreed to dismiss any associated charges. They also affirmatively recommended a sentence of no jail, no probation, fines, and costs only. At that time, as required, I ordered a substance abuse assessment, asked that a criminal and driving history be run. All of that has been completed, so we are able to proceed to sentencing today. And again, the prosecutor's office recommendation is contained in writing. Mr. Lyons, this is your chance to tell me anything you would like to for sentencing as well.
Just want to apologize for making a mistake.
Ms. Vogel, on behalf of Mr. Lyons for sentencing.
Thank you, Your Honor. Mr. Lyons' actions in this case are not in accordance with his typical behavior. He rarely consumes alcohol and before this incident had not drank in over 10 years. This was an isolated incident, and Mr. Lyons has noted to me that had he known that he was at that legal limit, he would have waited much longer before driving to ensure he was safe to drive. He also was only at a 0.082 BAC at the time of this incident. Since then, he has resumed his prior sober lifestyle and intends to resume it going forward. Additionally, Your Honor, Mr. Lyons does reside with his wife and their 8-year-old son. He does have stability. He owns the trailer that they've lived in for the past 4 years. However, he has a history of grand mal seizures and as a result receives federal disability assistance. And in addition to that, Mr. Lyons' wife's health has deteriorated significantly as a result of chronic Crohn's disease, which has resulted in emergency surgery to remove a large portion of her digestive tract this year, as well as heart issues that require a heart transplant. She's only 36 years old, but was recently placed on hospice care and is being cared for at home and receiving part-time home health services. However, most of the caregiving responsibilities are on Mr. Lyons. He is also the sole financial provider for the family, and the medical bills and prescription costs created significant financial strain over the course of this case, as he struggled to stretch his fixed income to cover these monthly expenses and additional health costs. Additionally, Your Honor, his wife does also have another surgery scheduled for the end of August, which will add additional financial and caregiving burden for Mr. Lyons, who is already battling intense exhaustion and stress. As a result, we do believe that any term of probation would be a further disruption at a time when he is already navigating overwhelming caregiving responsibilities, and the financial requirements of probation would likely prove to be incredibly difficult for Mr. Lyons to meet due to his limited income. And as I said, he was right at the legal limit and has not indicated having any kind of problem with alcohol. Finally, operating while visibly impaired is not considered a serious misdemeanor under MCL 780.811. There is a presumption under MCL 769.5 of a non-jail and non-probation sentence. Mr. Lyons has no prior drinking and driving offenses, and during this incident, his BAC was relatively low at only a 0.082, and there was no accident involved. The prosecution was comfortable agreeing to a sentencing recommendation of fines and costs only as well. We would request fines and costs only in this matter, and taking into account Mr. Lyons' current financial situation, we would request the fines and costs be minimized to the greatest extent possible. Thank you, Your Honor.
Mr. Lyons, as you know, you have an extremely lengthy criminal history. Your attorney doesn't mention any of that, of course, but you went to prison out of Montcalm County for a felony charge. I had a hard time deciding what to do in your case because I have to sentence you both on your criminal history and what you did in this case. Your criminal history is extensive. You've already been to prison. But in this case, sir, you had a chance to speak. You decided not to execute it. This is my chance to speak. But in this case, as your attorney indicates, there's some time between your prior convictions and this case. Your blood alcohol level was just at the legal limit. None of your prior convictions were for anything to do with drinking and driving. Plea agreement in this case called for no jail and no probation. And again, on the facts of this case, but for your lengthy criminal history for non-drinking and driving offenses, it'd be a pretty easy decision to make. What I've decided to do, Mr. Lyons, after looking at everything, is to do the following: follow the recommendation in the plea agreement in this case. And that means entering a sentence of no jail, no probation, fines, and costs only. On the reduced charge of operating while impaired, the fine is $300. Court costs are $400. State costs and fees are $125. There's a $100 oversight fee for that term. I'm sorry, $100 fee for the substance abuse assessment for a total of $925. Court file shows you're released from the Allegheny County Jail on a $500 personal recognizance bond. So all of that is due. We'll put that out for payment over the next 3 months. On this charge, we also have everyone complete a victim impact panel. Court staff is going to mail to you all the places you can go online to complete that, and you'll also have 3 months to complete that and send proof of completion of that back to the court. So, Mr. Lyons, you're free to hang up from the court proceeding. Court staff is going to mail to you everything I just said. The bottom line is you have up to 3 months to pay any fines and costs, and up to 3 months to complete that victim impact panel. Good luck to you, Mr. Lyons. Thank you, Ms. Vogel.
Thank you, sir. Have a good day.
You too.
All right.
Good morning once again, everybody. It is TCF Live on a Friday Eve. It is good to have you here with me. Let's continue to ride with Judge Skocelas for 1 or 2 more.
Yes.
File 260906 SM, People versus Anna Marie Rankin, was charged in this case through the Allegheny County Prosecutor's Office with a charge of domestic violence. At a final settlement conference before a jury trial on July 10th, you entered a plea to that charge. The plea was taken under advisement as the prosecutor's office was recommending a first offense deferral. The prosecutor's office at that time also requested we set this for sentencing at a later date for crime victim rights purposes. Ms. Winsemius, is Sherry Rankin present, or has she filed any type of impact statement with your office?
She is not present, but she has filed a victim impact statement with our office, Your Honor. At this time, we would ask to move forward with the diversion as well as allow for non-assaultive and non-threatening contact. Thank you, Your Honor.
The non-assaultive, non-threatening contact was agreed to by your office a month ago, back at the time of the plea on July 10th. Any indication from the police reports that alcohol or controlled substances were a factor in this case?
I don't have any information to that effect. Your Honor.
Ms. Rankin, this is your chance to tell me anything you would like to do for sentencing.
I don't have anything to say.
Mr. Goodrich, on behalf of Ms. Rankin.
Your Honor, I've spoken with Ms. Rankin several times in regards to this matter. This was a situation where the victim was her mother, and things just happened to get out of control in the house. Ms. Rankin is taking steps to get some medication that she's had changed and properly balanced, and we believe that in a year she will be clear of this and properly complete all conditions of probation. I do not, Your Honor, ask the prosecution. There was no alcohol or drugs involved in this, so we would ask that that not be a condition of probation.
Rankin, this deferral period is for a period of 1 year, and there is a $625 oversight fee attached to that, but you will have the entire year to pay that amount on a monthly payment plan set up through the probation department. While on probation, the probation department will have the authority to require counseling as they see fit, which is going to be whatever best for you to help you complete this year successfully. A no contact provision of your bail was already changed a month ago. And how has that gone for you since we changed that a month ago? Any problems with your mom?
No, we've been actually doing really well and have improved our relationship in a lot of ways.
She's always going to be your mother, so that's good to hear.
Yes.
So we're going to continue that as a condition of your deferral. Again, it's called no assaultive or intimidating behavior. And this is not just with your mom, but with anybody. And if you are not aware, if you do engage in any assaultive behavior at all while you're on this deferral under Michigan law, I've got to kick you off. So it's a mandatory thing. So nothing threatening or physical while you're on this, and this will hopefully all go well for you. At the end of the period, if you complete this all successfully, the probation department will notify my successor judge, and he or she will notify you by letter that your case has been dismissed. Today, the probation department is going to call you on the telephone to set up your probation order. They'll have you sign it electronically, so you won't have to come here into court. What telephone number can they reach you at today, Ms. Rankin?
616-879.
You are free to hang up the court proceeding. Be available at the telephone number you just gave us. You'll be receiving a telephone call at that number from our probation department shortly. Good luck to you, Ms. Rankin. I hope this all works out as planned. Thank you, Mr. Goodrich.
Thank you, Your Honor.
Good morning once again, everybody. TCF Live on a Thursday. Thank you for joining me this morning. Let's go to Ohio. Judge O'Donnell.
You seated. 21 CR 415 Charles Brickman, violation of community control, violation, failed to report June 5 and June 18. You understand that charge?
Yes, sir.
And the second violation, various charges out of Painesville Municipal Court for driving violations. You understand that charge?
Yes, Your Honor.
And then finally, a failure to report those infractions to your probation officer. You understand that charge?
Yes, Your Honor.
Mr. Hinton?
Thank you, Your Honor. At this point in time, Mr. Brickman would like to waive his final hearing and enter guilty pleas to the violations.
Is that what you want to do?
Yes, Your Honor.
What's your plea to those violations?
Yes, Your Honor. Oh, I'm sorry, guilty, Your Honor.
I'll accept your guilty plea and find you guilty. So what's the problem?
I didn't have access to my medication and just should have planned better, and I'm embarrassed and apologetic that I'm here in front of you, sir.
Why didn't you have access to your medication?
My doctor was out of town. She recently had a baby, and she was out of town on, or not out of town, on medication leave or maternity leave, and I just wasn't able to get
When was this?
June, beginning of June, June 15th, June 12th, June 15th.
Where do you go?
Crossroads in Minor.
And they didn't have anybody filling in for her?
No.
So what medications you take?
Adderall, Wellbutrin, I forget what I take for anxiety, and Sertraline for depression also, and for PTSD and my memory, for ADHD, my brain injury.
Are you taking your medication now?
No, I haven't had access to it since the 12th.
Why is that?
They won't give it to me in the jail.
Why?
I don't know.
Did they tell you why?
No, they just said they don't prescribe controlled substances in the jail because of abuse or people are cheeking them or not. I don't, to be honest, I don't know. But I have requested them on the kite or on the tablet every day since I've been here.
Is that accurate, Ms. Randallson? Do you know?
I am not sure of that, Your Honor.
Okay.
I was not aware that he wasn't getting any of his medications at all.
Oh no, I'm not. I didn't say I'm not getting any of them. I'm not getting the ones for the depression and the memory and the anger, the PTSD.
Because you've been causing quite a ruckus over there in the time you've been there.
I made some bad decisions.
Right. I mean, I got a whole bunch of reports. What's the story on the restitution?
It should have been paid a long time ago. I just had a lot of expenses with my children's private school tuition, my daughter's graduation party. I should have taken care of it a long time ago. It'll be paid before the weekend.
What?
It'll be paid before the weekend.
Mr. Hinton?
Thank you, Your Honor. In this particular situation, it appears that for a lengthy period of time, Mr. Brickman was compliant. Obviously had a bit of an issue in June of this year. Seems to have a good attitude, seems to be willing and able to pay the restitution. I would ask that the court consider releasing him from the jail and extending the probation in an amount of time to give him an opportunity to pay back said restitution. Seems like a lot of this is linked to the mental health and the medication. So the sooner he can get that under control, the better. And it sounds like he's getting some of the meds in the jail, but not all of them. If he were to be released, I believe that he'd be able to be back on all the medications, Your Honor. Thank you.
Well, I guess I'd like to find out, how long has he been in, Kim?
He's been in for 46 days.
Okay. All right. I'm going to, since you haven't paid your restitution yet, I extend your community control to June 29th of 27. You're going to serve 46 days with credit for 46. I'm going to give you till August 16th to pay your restitution in full.
Thank you.
I'm going to continue with Crossroads and follow all the recommendations. And I guess the question you should pose to Crossroads is, if your doctor got off walked off the curb and got hit by a bus, does Crossroads close down because they don't have any more doctors, or what the story is there?
Okay.
So you ought to address that with them if that's accurate, okay?
Yes, sir.
And then the remaining items you are to comply with that were put into effect on June 20th of 24.
Yes, sir.
But I do want to know, beyond that, and I'm going to put you in charge of this, Kim. I'd like to find out what medication he has taken at the jail and what medication he's not taken at the jail, and what the reasoning is if he's got medication available and they're not giving it to him. Now, it may be, since he said his doctor went on maternity leave, that he didn't have any medication, but I would think that the doctor over there would see him sometime during these 46 days to determine whether some should be prescribed if he didn't have any, because this isn't a unique problem to Mr. Brickman. This is a common problem that I need an answer to. Anything else, Mr. Hinton?
Nothing further, Your Honor.
Kim, anything else?
Yes, Judge. Did you say restitution, not restitution, I apologize, that his probation was extended until June 27th or June 29th?
29th of 27.
Okay.
Okay?
Thank you, Your Honor.
All right.
Alrighty, friends, good morning once again. Hi, Ellie. You want to say good morning to your friends? No? Okay. Let's go back to the Mitten State. We'll visit the Thumb, Huron County, Judge Prill.
7469 FH, time of date set for pretrial. The defendant is present, represented by Attorney Elizabeth B. Weisenbach, who's in the courtroom. The people are represented by Prosecuting Attorney Timothy J. Kowski. My understanding is that there may be a plea agreement here. Is that correct, Ms. Weisenbach?
Yes, Your Honor.
Sir, would you please raise your right hand? You swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
Okay. Mr. Rakowski, please take the terms of the plea officer.
Yes, Your Honor. Mr. Matthews would be pleading no contest to domestic violence third offense and being habitual offender second offense. People agree not to file any further habitual offender notice. The parties have stipulated to a guideline range of 12 to 30 months. And the people have indicated that if the defense is going to ask for 12 months, that we would not object to that.
Ms. Weisenbach, is that your understanding of the plea offer?
It is.
Mr. Matthews, did you hear the terms of the plea offer outlined just a moment ago?
Yes, Your Honor, I did.
Is that your understanding of the plea offer?
Yes, Your Honor.
Do you wish to accept it?
Yes, Your Honor.
Are there any other terms of the plea offer that we've not covered on this record?
No, Your Honor.
Have you had sufficient time to speak to Ms. Weisenbach about this?
Absolutely, yes, Your Honor.
Do you need any additional time to speak with her?
No, Your Honor, I do not.
Is there anything affecting your mind or brain making it difficult to make a court decision?
No, sir, not at all.
You have a clear mind?
Yes, Your Honor, I do.
All right. Any other terms of the plea offer, Ms. Weisenbach?
No.
No, Your Honor.
Thank you. Mr. Matthews, are you on any term of probation or parole?
Not at all, Your Honor.
Any information you're charged with domestic violence, third offense, habitual offender, second, which is a felony carrying a maximum prison sentence of 7.5 years in prison. In addition to that, be subject to a fine of up to $5,000. You'll also be subject to court costs, state minimum fees, crime victims' rights fees, or all of that. Do you understand the charge and the maximum sentence that can be imposed?
Yes, Your Honor.
Very well. Ms. Weisenbach, according to the information, on or about November 26, 2025 in Harbor Beach, Huron County, Michigan, how did your client plead to domestic violence?
No contest.
Reason for the no.
I have an independent recollection.
Any objection, Ms. Burkell?
No objection.
There's a proper basis, the court can proceed under that. So your plea is no contest, Mr. Matthews?
Yes, Your Honor, it is.
All right. Since you are in St. Clair County right now, you do not have an advice of rights form before you. And I'm going to go through an advice of rights form with you. I wish to advise you that you have a right to be tried by a jury. You have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. You have the right to have the prosecutor prove you're guilty beyond a reasonable doubt. You have the right to have witnesses appear at your trial. You have the right to question all those witnesses against you. You also have the right to have the court order any witnesses you have for the defense to appear at the trial. You have the right to remain silent during the trial, and your silence cannot be used against you. You also have the right to testify at trial if you wish to. You understand those rights?
Yes, Your Honor, I do.
All right. If your plea is accepted, you may be giving up the right to appeal issues otherwise be appealable if you were convicted at a trial. Further, any appeal from your conviction and sentence pursuant to the plea by application for leave to appeal and not by right. Do you understand that as well?
Yes, Your Honor.
If your plea is accepted and you commit misconduct before sentencing, the court will not be required to follow a sentencing agreement or evaluation. Misconduct includes but is not limited to failing to appear for sentencing, violating the bond condition, violating a sentencing or plea agreement, or failing to obey a different court order. You understand that as well?
Yes, Your Honor.
Fines and costs and other financial obligations imposed by the court must be paid at the time of assessment, except when the court order is otherwise for good cause shown. If you are not able to pay due to financial hardship, you can contact the court immediately to request a payment alternative. You understand that as well?
Yes, Your Honor.
So do you understand all those rights?
Yes, Your Honor, I do.
By pleading no contest, you're giving up those rights. Do you understand that?
Yes, Your Honor.
It means you will not have a trial of any kind or have any opportunity whatsoever to contest guilt, and all that remains after today will be for you to be sentenced. Do you understand that?
Yes, Your Honor, I do.
If your plea is accepted, you'll be giving up any claim this plea is a result of any promises or threats not disclosed in this court during the plea proceeding. You'll also be giving up any claim this plea is not of your own free choice. Do you understand that?
Yes, sir. Yes, Your Honor.
Other than the terms of the plea offer outlined on the record, has anyone promised you anything such as leniency to keep the plea no contest?
No, sir.
You understand that no one can make any promises from the court as to how the court will dispose of this case. That is, no one can promise that the court will be easy on you in imposing a sentence. Do you understand that?
Yes, Your Honor.
Anyone promise the court would be easy on you?
No, Your Honor.
Anyone threaten you to enter this plea?
No, Your Honor.
For your own free choice.
Yes, Your Honor.
Do you have any questions of Ms. Weisenbach?
No, Your Honor.
Any questions regarding any of your rights?
No, Your Honor, none at all.
Ms. Weisenbach, the court is in receipt of people proposed exhibit number 1, which appears to be Harvard Beach Police Department Incident Report 254602079. Any objection to its admission to that? Thank you. Court will review the document. Mr. Matthews, do you acknowledge being previously convicted of a domestic assault in the 72nd District Court on July 16, 2008?
Yes, Your Honor.
You acknowledge the same type of conviction in the same court on June 27th, 2022?
Yes, Your Honor.
And a previous conviction in the same court on May 31st, 2024?
Yes, Your Honor.
You acknowledge in 1992, July 27, you were convicted of breaking and entering a building in the St. Clair County Circuit Court?
Yes, Your Honor.
And as late as September 26, 2005, home invasion, third degree, in the same court?
Yes, Your Honor.
Mr. Rakowski, do you have any promises to register?
No, Your Honor.
No, Your Honor.
Has the court complied with the court rule concerning the plea?
Yes, Your Honor.
Yes, Your Honor.
Mr. Matthews, there's no agreement made by this court concerning this plea and the final result. Is that accurate?
Yes, Your Honor.
Yes.
Yes, Your Honor.
Court will accept the plea. It's done freely, voluntary, and understanding. There's a sufficient factual basis after review of the People's Exhibit 1. Clearly indicates that there was a domestic relationship between the victim in this case, as outlined in the information, as well as the defendant, and that there was a physical altercation at the hands of the defendant. Result court will accept the plea. We'll schedule sentencing for. We'll set sentencing October 5, 2026 at 9 a.m. Prior to sentencing, the court is ordering a pre-sentence investigation report to be prepared, provided to both counsel and court at least 2 days prior to sentencing. Sentencing guidelines shall be scored 14 days prior to sentencing, provided to counsel. Any objection to the scoring of the guidelines must be filed in writing with the clerk of the court, as well as probation within 14 days of 7 days of sentencing. The defendant must appear to the courtroom at the time of sentencing unless there are alternative arrangements made if the defendant is incarcerated, particularly in St. Clair. And with that in mind, any supporting documentation can be submitted to the court no later than 7 days from sentence. The objection or written response must be filed 3 days thereafter. $50,000 10% bond. Ms. Weisenbach, what's your position on bond?
What's the court's cancel bond?
Any objections for Caudill?
No objection.
Bond is canceled. That will conclude proceedings. Thank you.
Thank you, Your Honor. Thank you for the scheduling.
Alrighty, friends, TCF Live on a Thursday. Normally that court has really good audio, so something is loose there connection-wise or something. I'll have to sort that out. Anywho, let's go down to Florida. Wade Mercer, check in with him.
When he spoke. I know what it used to be like. I've been here, a long time. Before you were here, it switched, Mr. McDaniel. Trust me. That's not the point. The question is that they don't need to introduce themselves if the camera's not switching anymore. Is it switching at all when he introduced himself?
No, sir.
Okay. Thank you. So, ladies and gentlemen, we have our two attorneys today. We have Mr. John McDaniel, Assistant Public Defender, and Mr. Jake Mitchell, Assistant State Attorney here. And can you see and hear all of us?
Yes, sir.
Perfect. First case we have is Joshua Gautreaux. I may be mispronouncing that last name. How do you say your last name, sir?
Gautreaux.
Gotro. Mr. Gotro, you're here because you've been accused of 4 charges in Jackson County. They are possession of controlled substance, which was dextroamphetamine, possession of controlled substance, which is phentermine, possession of THC concentrate, possession of cannabis over 20 grams. All 4 of these are third-degree felonies. Your criminal history is lengthy. I've looked at your criminal history. There is probable cause in the complaint. I think you're entitled to a bond, though, so I'm going to listen to the attorneys before I address your bond status. Mr. McDaniel, anything?
Just reasonable bond, Your Honor.
Thank you. Mr. Mitchell?
We request that he be subject to random UAs.
Thank you. Mr. Gotro, I'm going to set your bond at $5,000 in each of these third-degree felonies. That makes your total bond $20,000, cash or surety. You have a condition of random urinalysis on the bond. That means you can be drug tested at any time, and if you test positive for something you don't have a valid prescription for, then most likely, it's very likely that your bond will be revoked and you would have no bond at that point. The jail is also going to give you a notice for your court date, sir. Your court date should be September 1st at 8:30. Do you have any questions?
Yes, sir. I do have my medical card in Louisiana that I'm okay. Yes, sir. Yep, I'm sorry.
It's okay. It's okay. It doesn't really help you. Mr. McDaniel or your attorney will talk to you more about that, okay?
No problem. I appreciate it, sir.
Have a good day, sir. Let me see. Joseph Peterson, Ryan McDonald, and Robert Alexander. Joseph Peterson, Ryan McDonald, and Robert Alexander. Gentlemen, your cases are identical for first appearance purposes, so that's why I'm seeing it at the same time. Mr. Peterson is on my left. Mr. Peterson, you have a holdout of Bay County. It's a child support matter. It appears to have a $10,000 purge. What that means, Mr. Peterson, is if you post a $10,000 purge, you'll be released. If you're not able to post it, you'll be held for Bay County. You'll get down there in the next several days. Do you have any questions, sir?
No, sir.
Wish you the best, Mr. Peterson. Mr. McDonald, your case is the same. It's also Bay County. It's also child support, but your purge is $4,000. Same thing applies to you. You have the right to post it. You'll get to use the phone also, just like Mr. Peterson, to try to post it. If you're not able to post it, then you'll be held for Bay County. Any questions?
No, sir.
Wish you the best, sir.
Thank you.
Mr. Alexander, you also have a hold for Bay County. Yours is a criminal matter. Yours is a grand theft charge that you've been accused of down there. There's no bond on the warrant. It looks like when you get to Bay County, the best I can tell, you're going to get a bond when you get there, but not until then. So you've got no bond for now. You also should be in Bay County in the next few days. Any questions, sir?
No, sir.
You also will get to use the phone, sir, in a few minutes to contact friends or family, okay?
Okay. Thank you.
So, yes, sir. Michael Macara. Mr. McCarr, good morning. You have a couple of different issues. I'm going to deal with the violation of probation first. In case number 25285 CF, you're accused of violating the terms of your probation. That VOP warrant has no bond on it. What I'm going to do this morning, I'm going to go ahead and arraign you on that, which means if you want an attorney appointed to represent you, I'm going to appoint the public defender's office to represent you if you want one. Would you like to have an attorney appointed to represent you, sir?
Yes, sir.
I'm going to appoint the public defender's office to represent you. Listen to Mr. McDaniel, and then we'll see if you have any questions on the VOP, and then we'll go to the new charge. Mr. McDaniel?
Your Honor, we're going to plead not guilty. We're going to ask to set this on the September 1st court docket. There'll be an attorney that'll visit him either on that day or prior, maybe on that day though, but that'll resolve that case today, or that portion of it.
Thank you. Mr. Mitchell, anything?
It is a weird situation because his original VOP was for technical violations, but I think it'll be an amended violation. So I think he is correct with the September 1st VOP date now. If not, it'll be either September 1st or September 3rd.
Is failing to report a technical violation under that statute? Yes. Failing to report is?
The tech
absconding is not, but failure to report is. Absconding is not, but failure to report is. So it depends on how many you missed, I guess.
Yeah, I think so.
So, Mr. McCara, that resolves that charge. Do you have any questions about the violation of probation before we move to the other case?
No, sir.
Okay. The other case, you're accused of one count of sexual battery, victim over 12 years of age, under 18 years of age. I've read that complaint. I sent a text to the attorneys this morning to look at that complaint and that statute. Let me see what the state's position is in that charge.
Your Honor, I've been in touch with the investigator that made the complaint. She is going to send in an amended complaint for the charge of unlawful sexual activity with certain minors. It's a second-degree felony, statute number 794.05. She was made aware of the facts of the complaint. So she's going to amend the charge and send it in for that.
Thank you. Mr. McDaniel?
I agree. There's probable cause for that charge. No objection. And yeah.
The second degree felony. Okay. The sexual battery, there's just some questions about that. There may or may not be probable cause on that, but considering that it's going to be amended, I'm going to find probable cause for the unlawful sexual activity with a minor. That clearly is the second degree felony, whereas sexual battery can be higher degree crimes. The problem, Mr. McCarroll, is you have a horrible criminal history. And I think there's a lot in there that makes me concerned about your being a danger to the community. Your bond is $100,000, cash or surety. In that case, no contact with the alleged victim. And you have the no bond I've already mentioned in the VOP. In that case, in the sexual battery case, you'll be given a notice for your court date of September 1st. You'll still be in jail unless something happens with that no bond VOP. Mr. McCarr, do you have any questions?
No, sir.
Wish you the best, sir. Darryl Bugs. Mr. Bugs, good morning. You have a violation of probation charge in 25225 CF. Let me get to that affidavit. There's a no bond warrant that's been issued by the circuit judge, Mr. Bugs. I'm going to go ahead and arraign you this morning and get you a lawyer appointed like you probably saw me do with Mr. McCara. Would you like to have an attorney appointed to represent you, sir?
Yes, sir. I just got out of jail, Your Honor.
Okay. Let me get you a lawyer appointed and we'll see if you have any questions. I'm going to appoint the public defender's office to 14th Circuit to represent you. Listen to Mr. McDaniel, please.
Your Honor, I spoke to Mr. Bugs. We're going to prove not guilty. I set this in the September 3rd court docket. I advised him that the current attorney that come out and speak to him prior to his hearing. Mr. Bugs wants to just tell you that basically he's saying that he got out of jail Monday at Dothan City Jail. We have contacted, because he got transferred from here to Houston County. We contacted Houston County. They said they released him when he finished his sentence there. He walked out of that jail. He says he walked straight over to the Houston County jail or the city jail and turned himself in. We contacted the city jail and they have no record of him being there. He says he was released from there Monday. I know I looked online also and I seen he was arrested in 23 and got released in 24. That's the last time they showed records of him being there. Not saying he wasn't there. I just don't have anything. So like I told him, I advised his attorney come speak to him and they'll go from there.
Hey, Your Honor,
thank you. Go ahead, Mr. Bugs.
Any way that I can get an earlier court date? My father, man, I just not got out. I'm overseas in him. He's 79 years old. All the social workers, everything with hospice. We've been dealing things with the other. I'm talking about, I really don't need to be here. It shouldn't be here. Well, and I understand I got to go down the red tape lines and stuff, but is there any way possible you can put
let me ask you a question. So let me ask you a question because I want to understand the timeline a little bit better. So according to the file, you were instructed by the probation officer on October 1st of 2025. That's when you're supposedly failed to report. So Corporal, please. Corporal may have something to add. Corporal.
Yeah. Okay. He was in custody here in the trustee bay until the date you just said. He had to go to Houston County. We transferred to Houston County. He was in Houston County. He got out of Houston County on 7/10. He's saying he reported to
the way it is,
Dothan City Jail. I called him. They said the last record they have of him being there was in 2024. But like I said,
but I was released. I was on that.
We know what you're saying.
No, I'm saying.
You listen to
them.
Quit talking.
So you gotta let the corporal talk. So the bottom line is there's enough confusion there. I'm not gonna get myself involved in another judge's case. You're gonna have to wait to see Judge Garcia, but Mr. McDaniel will notify the attorney seeing you, representing you of the situation. That attorney will come see you, okay?
So Your Honor, I know you're saying that you don't get involved with other judge things, but if it's showing that my violation for 2025 and record showing that I was here.
No, there are two violations. The first says that you had not reported as of that on October 21st, 2025, you were instructed to report, but obviously you couldn't. And they're saying that you did not report on 7/30/2026. The other violation is that it says that on 7/10/2026, you left the jail and did not report. So those are the violations they're accusing you of. And there's enough there. I don't know if you're telling the truth or not. I have no idea. Someone needs to look into it, but today's just the first appearance date. And right now the judge has set you no bond. Okay. Have a good day, sir.
Did we arraign him? Okay, sorry.
I don't know if I ran him or not. I'm appointing the public defender's officer to represent him if I didn't. Thank you, Mr. Mitchell. Kevin Dean and Tristan. I might be mispronouncing that. If I am, I apologize. Mr. Dean. I'll go ahead and let you sign that.
They call
All right, Mr. Dean, you have a warrant out of Colquitt County, Georgia. I just seen you sign something right there at the jail. I'm going to assume that was a waiver of extradition. Is that correct?
Yes, sir.
Mr. Dean, do you have any questions about that waiver of extradition process?
Yeah, if the charges are dismissed or whatever, does that still mean I'm going since I signed that, or
If
that
they
mean I'll be
notify our jail in writing that they no longer want you, doesn't matter what the reason is, that's their call. If they notify us in writing that you no longer wanted, you're released immediately. Doesn't matter if the charges are dismissed, doesn't matter what their reasoning is. But if they say it's too far to come get him, it don't matter what their reasoning is. If they send us something in writing today or tomorrow or anytime before they pick you up, then you'll be released immediately. Any other questions?
That was it.
Okay, so I'll see you in 15 days. If you're still here, that's unlikely, but possible. They have 30 days to pick you up. Then we have Tristan Kenham. Sir, how do you say your last name?
Kenham.
Kenham. Mr. Kenham, good morning. You're here for that. It looks like you signed a waiver of extradition before Judge Costello for Pender County, North Carolina, and you're being brought back up today just to see what the transport status is. Corporal, can you give us any information on this case?
Yes, sir. We have a date. We've been in communication with them. They'll be here to get him within the time frame, and he will be gone.
Thank you. So, Mr. Kenham, they don't publicize the actual dates for safety and security reasons, but you heard everything that I just heard. If by any chance they're not here to pick you up within 30 days from the day you signed that waiver, you're released. Do you have any questions?
No, sir.
Have a good day, sir.
You too.
Mr. McDaniel, I know that we have an add-on, but I'm not sure if it's in person or if he's in person.
Yeah.
Okay. It's from the jail, Mr.
Cody Clemens.
Mr. Clemens, but he's here in person, right, Corporal?
Yes, sir.
So I think that's it for first appearance with the jail. Mr. McDaniel, anything else from the public defender's office?
No, Your Honor.
Thank you, Mr. Mitchell.
Nothing for first appearance purposes.
Corporal, anything else for first appearance purposes?
No, Your Honor.
So, ladies and gentlemen, that concludes first appearance court. We do have a potential or possible, we've got a case coming up in violation of probation, felony case I'm covering, and we'll start a new recording that should be in the next 5.
Alrighty, I guess he's done for now. TCF live on a Thursday, wrapping up hour 1. Thank you all for joining me this morning. Let's go back to Allegan County, Michigan, check back in with Judge Skocelas.
Back on the record on file 260618SM, People versus Albert Diaz. We called this case at the beginning of the docket. At that time, Amanda Lindahl Lemke was not present. It sounded like maybe she was trying to contact the court. This matter was set for sentencing at 8:30. It's now 9:35. Ms. Winsemius, we've had no contact with her. Has your office had any contact with her today?
No, Your Honor. Imelda Pope from my office has been attempting to reach her this morning unsuccessfully. So at this time, I would ask the court proceed knowing that information.
In this case, Mr. Diaz was charged through a misdemeanor complaint issued by the Allegan County Prosecutor's Office with a charge of domestic violence. At the time of a pretrial conference on July 10th, they amended that charge to a charge of assault and battery. At that time, they recommended a sentence of no jail, no probation, fines and costs only. And again, recommended that we set this up for sentencing under the Crime Victim Rights Act. And it looks like Mr. Diaz is currently on probation for the next 2 years on a charge of stalking. that occurred 1 month after this case. So Mr. Diaz, is that true? You're currently on probation for stalking?
Yes, Your Honor, I'm currently on probation for that.
And it looks like for the next 2 years, so out to May of 2028?
Correct.
Okay. Mr. Diaz, you've heard the prosecutor's recommendation on this case. This is your chance to tell me anything you'd like to for sentencing.
I just want the court and you to be known that I've been doing the process. I haven't had any issues with the probation officer. I've passed all my drug tests, my alcohol tests, and I've been starting paying my court fines, and I apologize for the matter that's happened, and that's just, we just proceed to just move on.
Ms. Strasser, on behalf of Mr. Diaz for sentencing on this case.
Yes, thank you. I can confirm I did reach out to probation just to check in and see how he's been doing. They said he has been off to a great start. He's been very compliant with testing, hasn't missed any, and all tests have been negative. He is currently working on locating counseling that participates with his insurance, so he will begin counseling soon, and he has made a payment towards fines and costs. I can also let the court know he has retained employment throughout this entire process, and they have been willing to work with him through everything, which has been great. We've had no issues with the no contact order. We would ask as well that that remain in place, or I should say we're not objecting to that remaining in place for the duration. So we would ask the court to follow the recommendation for fines and cost. Thank you.
And given the fact you're going to be on probation on the other case for the next 2 years, I will follow that recommendation, impose a sentence of no jail, no probation on this case, fines and costs only. The charge of assault and battery, the fine is $500, court costs are $300, state costs and fees are $125 for a total of $925. Court file shows you're released from jail on a $500 personal recognizance bond, so all of that is due. We'll put this out for payment over the next 90 days. So Mr. Diaz, on this case, what you should do, if you are able to, is take care of this fine and cost first. You'll have 3 months to do that. You're going to have, I'm assuming, a full 2 years to pay off your fines and costs on your other case. But you're not on probation for this case, so you won't be paying through the probation department. You'll be paying directly through the court. And if you can get this one wrapped up first, then you'll have, again, 2 years on your stalking case to pay off the fines and costs on that. But the case is closed today, and with that, the protective bond is going to be canceled as well. Okay?
Okay.
Good luck to you, sir. Thank you, Mr. Strasser.
Thank you.
All right, friends, let's head back to Florida. That gentleman that Wade Mercer said was like an add-on. He's in the courtroom now, so let's check that out.
Your Honor, this is Cody Clemens. He's here in case 22-441 CF. At this time, Mr. Clemens is going to admit the violation of his probation and enter an open plea, and we would request that sentencing be deferred until, do you have a date in mind?
We could do it at the next case management conference, which I think is September 10th.
Okay.
Is normally Miss Kelly on the case? I'm trying to take into account her calendar. Are you normally on the case management day, or are you on the public defender day? The September 10th work at 1:30.
As far as I know, that's a Thursday, right?
Yes,
Yeah.
that's a Thursday.
All right, and is there a written plea form?
Yes, sir.
All right. So, Mr. Clemens, let me get you to raise your right hand, sir. You solemnly swear or affirm the testimony about to give in this case to be the truth, the whole truth, and nothing but truth to help you God.
I do.
Mr. Clemens, you're on supervision, or you're still on supervision for a what degree felony, Mr. Mitchell? Third degree?
It is third degree.
Third degree felony. You're accused of violating the terms of your probation or community control. Mr. Clemens, you have the right to a hearing. Actually, we'll have a hearing scheduled this afternoon. At that hearing, you'll be represented by an attorney. And at that hearing, the state will be trying to prove that you violated your probation or supervision in a material and substantial way. Your attorney will be defending you and arguing otherwise. But if you enter this plea, you're waiving that right to a hearing. Do you understand that?
Yes, sir.
You will not get to call witnesses. Actually, that's not necessarily true, because I believe the plan is to set for a sentencing date, correct?
Yes, Your Honor.
So you will still get to call witnesses, but the witnesses won't be arguing that you didn't violate your probation. The witnesses may be arguing other things in your favor other than that. Does that make sense? But you will not get the issue of innocence or guilt, or did I violate my probation or not, is not the question I'll be deciding. The only question I'll be deciding is what is the appropriate sentence, given that Mr. Clemens has admitted violating the terms of his supervision. You understand that?
Like a character witness?
You can call whoever you wish. You character witnesses, you call anybody that you think is relevant to the issue of any mitigating factors regarding that should be considered for sentence. Character witnesses, employment witnesses, anything that you think is relevant. It's got to be relevant to the sentence that I've got to impose. So, but the bottom line is that you will not have a violation of probation hearing. You understand?
Yes,
You're waiving that right. And an open plea means that you are not accepting the state's plea agreement. Frankly, I don't know what their plea agreement is because I'm relatively new on the case. Whatever their agreement was, you're not accepting it. You're saying, Judge, I'm going to throw myself in the mercy of the court. That's what an open plea is. You understand that?
Yes,
the maximum penalty I can impose in this case, I'm not saying I would. I just have to tell you the maximum is. The maximum penalty is 5 years in the Department of Corrections. That's the maximum I can sentence you to. I can sentence you to as little as reinstatement or termination of probation if I thought there was a really good reason to. But somewhere in between there is what you're going to be sentenced to somewhere between the minimum and the maximum. You understand that?
Yes, sir.
Okay. Are you under the influence of any substance today that may affect your ability to do what enter this plea or this admission?
No, sir.
Do you feel like this is in your best interest?
Yes, sir.
Are you satisfied with the services of your attorney?
Yes, sir.
Do you have any questions you want to ask me, Mr. Clemens, before I accept this admission?
No, sir.
Okay. I'm going to accept the admission that you violated the terms and conditions of your supervision in case 22-441 CF. I'm going to find that the admission is freely and voluntarily entered with the advice of counsel. As far as sentencing, number one, the score sheet in the file is outdated. So, Mr. Mitchell, I need a new score sheet, and I need you and to give Ms. Kelly, obviously, and Mr. Clemens a copy of that before the sentencing date so that they can look at it and see if there's any errors with the score sheet. The one in there is before, it's on a prior violation. I think this is the second violation when I looked at the file yesterday. So the one in there doesn't include this violation. The second thing is a date. Mr. Mitchell, Ms. Kelly, Mr. Clemens, given that you may or may not want to call some witnesses. The email yesterday mentioned something about trying to coordinate with Alabama authorities. So help me understand that. Is he on supervision in Alabama?
So the underlying allegations in this violation were that while he was on probation here, he was out of the county without permission. He was in Alabama and he was arrested for a possession charge and he was placed on probation there. So
it's not a pending charge in Alabama. And I read your letters. I have read your letters. When I looked at the file, Mr. Clemens' concern is if they put a detainer on him, it would affect going to work camps and so forth in the Department of Corrections. Correct?
I do have a warrant there because they put me on probation and they let me out. So I didn't have my truck or nothing like that. So when they wanted me to report probation the next day, I was walking down 231. You know what I mean? So
how long before you got taken into custody here after you pled?
So 6 days from
Okay.
I got let out there till I come here.
So between now and the sentencing, you're going to try to explain to them. I'm asking a question. It seems to me from reading the letters, you want them to understand what's going on here,
right,
so that hopefully he won't have a detainer on him if he gets a Department of Corrections sentence. That's the goal.
correct. And then hopefully he won't, be in a situation where he serves a sentence here and then they want him to serve another sentence. So I've got a little bit better relationship with Georgia than I do Alabama, but we're trying to get something worked out for both.
Okay. We can't release him. I know we can release him to other counties, but once he pleads here, I can't release him to another state without a court order from that state to come pick him up. Is that correct? That's the way I understand the law.
The way I understand it, Your Honor.
I've not done much interstate, so I believe so. And I had suggested to Mr. Mitchell or run the idea by him, what if we plea him, let him have some sort of form of release here before sentencing to go turn himself in up there. With the understanding that if he voluntarily doesn't come back, that the plea would be binding still and that he may face additional charges. But I think Mr. Mitchell wanted to see if I could get somebody first before we went to that.
Yeah, that's probably not going to happen. Just because we'd be in the same situation Alabama's in. We'd be waiting. So, Mr. Mitchell, have you communicated with the prosecutor up there?
I have attempted numerous times. I've left contact information, have not received a call back, despite even knowing who the prosecutor is that was handling the VOP up there. And I believe discussions with Miss Kelly yesterday was she may try to actually go in person. And I said, if push comes to shove, I may even go up there in person.
Okay, so given all that y'all want to do that to try to give Mr. Clemens some answers to his questions, which seem to be very reasonable, frankly, I'd probably want to know the same thing if I was in your shoes. When do we need to set a sentencing for? How far out do y'all need? Is the date that we talked about just a minute ago, is that
September 10th. I think that should be
Yeah,
adequate.
that'll be plenty.
It's going to give y'all just a hair over a month to
We can get that.
wrap all this up so that you can do the best job you can presenting his case to him. Okay. Is that what you're asking for, September 10th?
Yes, Your
Mr. Mitchell?
No objection to that.
Mr. Clemens, any questions?
No, sir.
Okay, so I've accepted your plea. I'm going to schedule sentencing for September 10th, and that's a 1:30 docket.
Yes.
September 10th at 1:30 will be the sentencing. Mr. Clemens, and hopefully, if it's another county in Florida, it'd be much easier.
Yes, sir, I understand.
But when you involve another state, it's very difficult. And in fact, I don't know that I've ever seen someone successfully do it. The best I've seen is where someone says, here's the commitment we've got from Alabama. Here's what they promised to do. Your best hope is that they say it's a simple possession. If he goes to prison in Florida, we're satisfied with that. We're not going to do anything else. That would be your best hope. It certainly could be worse than that, depending on what they say up there.
From the time I was there, when I seen them like technical violations, like is what I did there, they do 30 days. You said 30 days and then they.
But did they put you back on probation?
Yeah, but so, I mean, I don't know what they would do with this. I mean, my whole thing was I was thinking, maybe get a motion transfer, go down there and handle it and then come back.
And that'd be great, but we have two different states, so I can't transfer you to Alabama. And I think an Alabama state court judge can issue a warrant to pick you up, but I don't think he can do an order. He can't do an order, he or she can't do an order requiring Alabama authorities to leave the state. He can't order our sheriff's department to do anything. He or she may be able to order Alabama authorities to come pick you up with a court order. And if they do that, then we'll see you when we get back. When we get you back, we'll put a detainer on you. But I don't have authority to order our people to take you to Alabama. I'm almost certain I don't. But Ms. Kelly will look into all that.
I can't file a motion in Alabama court, which is the problem.
So we'll see where we stand, and we'll see you on that day. We'll do the best we can to impose a fair and consistent sentence. Anything else on behalf of Mr. Clemens, Ms. Kelly?
No, Your Honor.
Mr. Mitchell, anything?
Nothing from the state.
Any questions? All right, we'll see you on that date, sir.
All right, thank you.
Have a good day, sir. Thank y'all.
I'll have that amended score sheet.
So, ladies and gentlemen, that concludes our short VOP docket today with only that one case. So court is adjourned.
Alrighty, friends, hour 2 of TCF Live. Let's go back to Ohio new contestant in front of Judge O'Donnell.
To count 1, domestic violence, a felony of the 3rd degree, and count 2, menacing by stalking, a felony of the 4th degree. At that time, a pre-sentence report, psychological evaluation, and victim impact statements were ordered. It's the state's understanding that the evaluations have been completed and provided to the court, and that the victim impact statements have also been completed and provided to the court, and that all parties are prepared to go to sentencing at this time. Thank you.
Mr. Mulkey. Ready to proceed, Your Honor. Thank you. Your Honor, my client is 46 years old. He's married. He does have a GED. He indicates he has a valid license. We'd be asking the court to consider community control. We understand there is a presumption for prison that has to be overcome. Since prison is not mandatory, the court does have latitude in consideration of a community control sanction, which my client would like to take advantage of if it is available. He indicates that if he is released on community control, he would be staying with his godbrother in Richmond Heights at 27038 Chardon Road, apartment 116, 44143. He indicated that he was last employed at a Body Code, an airplane manufacturing company, where he would test the integrity of airplane jet parts, making them more durable through a heating and treating process. He'd like to resume that line of work in some way, shape, or form. We understand that he's got a history of domestic violence and has prison as well. However, after conferencing with my client, he has relayed to me that he's been taking some psych medication and seizure medication, and I asked him specific what he was taking rather than generalizations, and he was very forthcoming with the fact that he is taking a medication called Keppra for seizures and Lamotrigine for psychological issues. I saw in the recommendation for his evaluation, there was a recommendation for Neocap and dual diagnosis treatment. and then sober living. If that is available and the court's willing to consider that, my client's willing to do that, I would ask the court to carefully consider that as an alternative to incarceration in the prison system. When he's on his medication, he appears to be lucid. Perhaps there's some anger issues there that need to be addressed. It seems very likely in terms of how he does treat his family members. There's no excuse for it. So we are asking the court to take all of that into consideration today. Judge, thank you.
Mr. Barber, what do you want to tell me before I impose sentence?
Is it all right if I stay, Your Honor?
Yeah.
Oh, good morning. How you doing, Your Honor? I was just wanted to tell you what please do to get another chance at life, any type of probation or mental health. I've been taking my Keppra. That's for my epilepsy, and that's a psych med as well, 750 milligrams. I've been taking Lamotrigine, that's a psych med, and for my epilepsy as well. And I know that I made a mistake and had a situation wrong, my son and my family. I just couldn't take my son being rude and disrespectful to me for a long time. And I handled the situation in the wrong way, Your Honor. And I'll just ask you what please me to get a second chance in life so I can get back to work, so I can pay my mortgage, my property taxes, Your Honor, so I can show you that I can listen to you, listen to my probation officer, live a normal life. I don't do drugs, Your Honor. I don't do alcohol, Your Honor. I don't hang around criminals. I don't run the streets. I'm a family man. I go straight to work and come home. I can obey the law. I know I have prior DVs. Those are verbal abuse DVs with my first wife. I'm married again with my second wife, living out in the house that I own in Lake County on 305 East 323rd Street, Willowbrook, Ohio, 44095, Your Honor. And I just want to be able to get a second chance in life, Your Honor. I've been taking my psych meds. I haven't been talking to my family. I have another place that I can live so I can reboot and regroup and focus on life, Your Honor.
How long have you been taking these psych meds?
I've been taking Keppra for about 5 years.
Okay, who prescribed that?
That was a doctor, a neurologist called Waiver.
Okay.
From the University Hospital, sir.
So, why did you go to that? Why did you go to UH for that?
Oh, well, I was on Tegretol XR before, and it stopped working, so I had to go to another medication, sir, and they Keppra was working wonders for me so I can stop having seizures, because I haven't had seizures in over 3 years, Your Honor, for my epilepsy.
So how long overall have you been involved with mental health medication?
Since 1999 or 2000.
Okay. So you've known of this condition or these conditions for 30 years, close to 30 years, right?
Yes, Your Honor.
Okay. So why does this stuff keep happening then? Because you've got 5 prior domestic violence, the last one a felony 4 a couple of years ago. You got 2 separate cases that are assaults.
Oh, Your Honor, my old DVs were in Cuyahoga County with my first wife, Your Honor. And the last court case I remember having in Cleveland was like an assault. I spazzed out, I had a seizure, and they said I assaulted the paramedics and the police officer, Your Honor. I blacked out, I didn't know what happened. I was in University Hospital on Chardon Road in Richmond Heights, and I was in coma for like 3 or 4 days, and when I woke up, they asked me what year it was. I didn't know what year it was, so I stayed in the hospital even longer, Your Honor, until I guess I came to my senses, and they told me that I assaulted the paramedics and the police officer.
Okay, so what happened with these cases against your son and then against your wife?
For my son, Say my son was being unruly to me for the past 6 months, Your Honor. I just kept giving him chances and chances over and over again, and trying to sit down and talk to him and not put my hands on him, Your Honor. I just kept talking to him over and over again. He's being disrespectful to me, my wife as well, Your Honor. And to tell you the truth, I had a mental health breakdown and couldn't take it anymore, Your Honor.
What about your wife?
My wife was just getting involved, and she was trying to stop us from fighting each other, Your Honor.
So are you telling me this really isn't your fault? It's your son's fault?
No, I'm not saying that, Your Honor. I can't put all my blame on my son because that is a lie, Your Honor. It's my fault and my son's fault as well, Your Honor. I can't put all the blame on anybody else, Your Honor.
So what was the physical contact you had with your son that's the result of this case?
Well, we were wrestling around. I kicked him in his nose, Your Honor.
When you were wrestling?
Yeah, I pushed him off of me and then kicked him in the nose, Your Honor.
Okay. Any other incidents?
Yeah, he had a box cutter. I took that from him, and my wife pulled it out of my hand.
And she got cut, right?
Yeah, she got cut on her index finger.
What were you doing with the box cutter?
I took it from my son. He works at Walmart. Him and my wife both work at Walmart in East Lake on Vine Street, and we bringing box cutters on. And my son's coming home from Walmart.
Why did you take the box cutter from him?
I didn't want him to cut me or anything like that, and I just snatched the box cutter from him.
Why did you think he was going to cut you?
Because he was really upset and mad and scared of me. I told him, I threatened him before he came home from work.
Why?
Because he was being unruly and talking smart to me and being very disrespectful, and I just couldn't take it anymore, Your Honor.
When was this?
This was a little bit after Christmas, Your Honor.
Okay. When did you give him that Lexus to use?
Pardon me?
When did you give him that Lexus to use? Or give it to him?
Probably about a year ago.
Okay. When did you give him this $4,000 to hold?
That was around tax season. I gave him my tax money to hold for him.
This past year?
Yes, Your Honor.
Why did you do that when in your eyes he's been such a pain in the rear end to you and a smart ass? Why did you give him $4,000?
Because he's real good at holding money, Your Honor, and my wife works at Walmart. It seems like she likes to spend a lot of money and let it dwindle down.
Okay. Did you give him the Lexus? Did you give him the car? Or did you give it to him to use?
I gave it to him to use, you know.
Why didn't you take it back if you gave it to him to use? If he was being a smart ass, why didn't you take it back from him?
Because my wife is using a Toyota, and I didn't want my son to walk to school. She had to go to work at 7 o'clock at Walmart in East Lake, Your Honor.
Well, listen, if I had a son that age who was being a chronic smart ass like you're portraying it, okay, and I was letting him use my car, I would say, you know what, leave a half hour early and walk to school. If you're going to be a smart ass, I'm not going to let you use the car. See, the point is I don't believe you. I don't believe what you're trying to sell me here.
Oh, well, that's the truth.
I mean, because you're a violent person. Because I look at your past.
Yes, Your Honor.
And you kind of soft sell these domestics as all verbal things with your first wife.
Yeah, a lot of them were with my first wife.
They may have been with your first wife, but I find it not to be believable that it's just a bunch of arguments with your first wife, and then you get charged with domestic.
It was, Your Honor, out in Maple Heights and Garfield Municipal Courts. Well, I had my first son with her when I was younger, Your Honor. In my 19 years old, in my 20s.
This thing with the box cutter, were you playing around with a joint? Is that what it was? And your wife talk to you about that and try to take it from you and you cut her?
Yeah, she just snatched it out of my
But it was
hand.
about marijuana, right?
No, not about marijuana, Your Honor. A joint, not about marijuana, Your
You don't
Honor.
use drugs, right?
No, I don't use drugs, Your
Then why do you have drug convictions?
I have one drug conviction in maybe like 99, 2000.
You've got a trafficking in cocaine in 2000.
Yeah, that was a long time. 2000, I was 20 years old. I'm 46 years old now, Your Honor.
And you went to prison for that.
Yes, sir.
Got out in 01. You only did about 5 months, 6 months, but you got out, and then there's a marijuana conviction in 02 and 03. There's a drug abuse.
That's what
In
I'm
09, there's a drug abuse. In 14, there's a felony drug possession. So you do play around with drugs.
That was a long time ago, Your Honor.
17, there was a drug abuse. So that wasn't a long time ago. You've been dealing with this mental health and on medication since '99.
Yes, Your Honor.
You're playing around with drugs during that entire time period, and you're violent.
Yeah, I do have a violent history, Your Honor.
I know. And I think you're trying to soft pedal what happened here, quite frankly.
No, Your Honor, or they're trying to soft pedal. I told you the honest to God truth. The reason why I didn't want to take my Lexus from my son, Your Honor, is because he's been going to school late, and I don't want to be school late. He's supposed to learn welding this year covered up, and I didn't want my son to be in school late. And my prior convictions with DV were when I was young and very dumb, Your Honor.
Okay, Ms. Cutts?
Thank you, Your Honor. Your Honor, it is my understanding at least one individual would like to address the court.
Okay, then just state your name and tell me whatever you want me to know.
Good morning, Your Honor. My son, well, I've been with David for 20 years now. I've been married to him for 13 years, okay? I've tried to get him to change his medication, the Keppra. They put him on the Keppra when he had a pancreatitis, and it seemed to drastically, well, he was already kind of abusive, and it made it even worse after he took it. Me and my son both begged him. We got him to go to another doctor, university, up in Menor. They changed him onto another medication. He stopped taking it because he was getting constipated off of it, and he never went back and tried again. Now, as far as the car, he gave that car to my son, and my son has been paying him $600 a month for that car. And I have it wrote down that he has a record of it. Every time he paid him, wrote down in his book, okay? Now, I do love David. I eventually want him to get the mental health that he needs. I know that this man has problems, okay? He needs to get the mental health, and I don't really know what else to say about it.
All right, thank you.
Oh, and my son is a good kid. He goes to school, he gets good grades, and he has his license. So I don't know what he was talking about today.
I believe the son would also like to address the court.
All right, my name is David Barber. I'm in relations. I'm his son. I would like to say that all the stuff that he said was a lie. I can't trust him anymore. He did give me the car. We came to an agreement. He said he wasn't going to pay for it because he wasn't working anymore. He got fired from Body Code in 2022. And also, and this abuse been going on ever since I was a child. I've been seeing my mom getting beat by him. Also, with that box cutter situation, he did have a box cutter. He was slicing blunt, Your Honor. And they was arguing about something, and it turned physical, so I tried to break him up. And when I tried to break him up, he assaulted me, Your Honor.
All right, thank you.
Thank you, Your Honor. This case encompasses, as the court is aware, two different victims. Count 1 deals with his son, and Count 2 deals with his wife. Count 1 deals with an extended period of time that does include the incident with the box cutter and kicked in the nose. Prior to that incident, there was also an incident where he punched his son in the mouth and split his lip. That would have been in January of 2025, as well as where he put his hands around his neck, leaving some marks in November of 2025, with the kick in the nose and the box cutter being December of 2025. There were also various times of threats that were made. It's the state's understanding that that was a pretty constant, regular thing. The state was provided with recordings of various threats made by the defendant to either his son, his wife, or both of them. Going back to December of 2024, there was also April of 25, July of 25, August of 25, September of 25, November of 25, December of 25, March of 26, April of 26, and May of 26. Well over a dozen recordings of statements such as shooting or killing, hurting, things of that nature, as well as other behaviors that would be upsetting and concerning.
Well, part of that, if I'm correct in what I'm recollecting, is that the threat to kill him and then get him to stand off with the cops so they kill him, right? Isn't that part of one of the
he has made
tirades?
He has made statements
right.
that I don't know if that's included in the actual recording that I have, but that is information that I have received as well. And he also told probation that if he wasn't able to be with his wife and his son, that he would kill himself. So he makes statements of that nature to multiple people at different times. All of those obviously concerning and have an effect on both his wife and his son, understandably. So we do have here arguably injuries exacerbated by age. As his son has stated, this has been going on a long time. These actual charges are when his son was 15 or 16 years of age. He is soon going to be turned 17. The victims have suffered physical and psychological harm. Obviously, it's very emotional and hard for them because this is a family member for them. However, when somebody acts this way or treats you that way, it's very difficult mentally and emotionally, as well as there have been physical injuries that have been spoken of. The relationship with the victims facilitated the offenses. Obviously, that is required for domestic violence. It is not required for the menacing by stalking. This was committed involving a parent in front of a child. Granted, he was a teenager, but as he has indicated, this is not the first time. There is a history of both juvenile adjudications and criminal convictions for the defendant. His juvenile history began in 1992. There was appears to be a misdemeanor burglary in 97, a misdemeanor assault, and in 1998, a felony burglary and misdemeanor theft. He began his adult history in 2000. As the court has stated, he had a trafficking in cocaine, a felony 4 conviction that he did go to prison for. He also had a domestic violence, which he had a probation violation and failure to appear on. 2002, drug abuse, an open container. 2003, drug abuse, as well as a domestic violence and an OVI. He had a probation violation on that domestic violence. 2005, domestic violence and a criminal damaging. 2007, criminal mischief. 2007, a DV. He did have a different case that was dismissed in 2007 that would be very concerning, but there was no conviction when the victim did not appear. In 2008, disorderly conduct and obstructing official business. 2009, drug abuse. 2014, contempt of court, a felony drug possession with a probation violation, as well as a felony DV with a probation violation. 2017, marijuana. 2018, obstructing official business and resisting arrest. And then in 2019, that's the assault on a police officer, felony 4 and resisting arrest. There was a probation violation. in that case as well. So he did have prison in 2000, 2001 for the trafficking in cocaine. He has not responded favorably to previous sanctions with the continuing nature of the charges and new charges, as well as probation violations. In his pre-sentence report, the statements that his written statement as well as his interview to probation seem to carry a lot of victim blaming as opposed to taking responsibility for what was occurring and has been occurring. It's also very concerning to the state the issues that the defendant had within the jail. There were numerous incidents in the jail that included yelling, screaming, swearing, faking medical issues. At one point he said to corrections officers, if I don't get toothpaste, I'm going to kill myself. They had to put him in a suicide prevention smock. So there are a lot of statements and incidents that happened in the jail between May 21st of 2026 and July 19th of 2026. Even though today he has said he doesn't use drugs or alcohol, there's been information indicating that's not accurate, as well as he stated that he does sneak away to drink since his wife does not agree with his drinking. The state is concerned whether there's really genuine remorse based on what he has said to this court in probation and what seems to actually be the truth. So we do not feel that he has overcome a presumption for prison on count one. We do think the state feels that prison is consistent and that he's not amenable to community control. So based on that, we would ask this court to sentence him to a prison term in counts 1 and count 2. He has 78 days credit. Do you think the court has the ability to do consecutive service, consecutive sentences based on his history of criminal convictions, with the 5 prior, making this the 6th domestic violence, as well as all the assault and obstructing and resisting arrest charges? Obviously, there are 2 victims in this case covering a very time period. He does have mandatory PRC, and that would be the state's recommendation at this time. Thank you.
All right, I've reviewed the pre-sentence report, the psych evaluation, the victim impact statements, and I have considered all the provisions in 29, 29, 11, 12, and 13. I have indicated the bulk of your record, as did Ms. Cutts. And as I stated, I don't believe what you're telling me. And specifically, there's an indication of a long-term use of cocaine also. That you talk about not using drugs. But more concerning than anything is your penchant for violence. And you've had a long-standing mental health problem that you've been under care for. And you sometimes, appears to me, sometimes treat, sometimes don't treat, and all the while using illicit drugs. And couple that with your anger problem, and you're a dangerous person. You've demonstrated objectively that you're a dangerous person. And you have come here and you've tried to soft sell what you did, why you did it, and essentially blaming your son for being unruly and blaming your wife for letting him be unruly.
Yes,
and that's that's the excuse that you've given for the physical assaults. And as I said, I don't believe that that's the case. I believe that you've been violent for quite a while, and you were violent in this situation. And so that's what we're dealing with.
Will I be able to say something, Your Honor?
Go ahead.
I was put on probation in 2019 for my last case when I had a seizure, and they said I assaulted a police officer, the paramedics. I didn't violate my probation. I was put on house arrest. I was put on probation for 5 years. I went down to Cuyahoga County, downtown. I was dropping a urine every Monday, and I completed my last probation, Your Honor. It was like extreme probation. Every week I dropped a drug test, and I completed some some anger management, and I think maybe some alcohol anonymous Zoom classes. I completed my probation. That was a lie. I did not violate my probation, Your Honor.
Okay. Well, let's assume that that's accurate, and I'm not going to evaluate probation in Cuyahoga County. I'm not going to assess that. Okay, but so you complete it, and then this verbal and physical abuse picks up, and which culminates in you sitting here today. So whether you complete it or not is not very consequential in my thinking, because if you did complete it successfully, you went right back to the same activity that you've been doing for 30 years. So what good did it do?
I just feel that my family been telling me I need a mental health evaluation. They've been trying to make me change my medications because they said I would have the capital ranges, and I said they were telling me I needed mental health. I just didn't really pursue that, Your Honor. I thought that they were trying to, make fun of me or put me down, Your Honor.
Well, you've been dealing with this problem for upwards of 30 years, so you knew you had it, and now you're saying that they were. It doesn't make any sense to me. There is a presumption that a prison sentence should be imposed in this case. You have not overcome that presumption. So in consideration of everything on count 1, I'm going to sentence you to 36 months in prison. On count 2, 18 months in prison. Those will be concurrent to one another, with credit for 78 days that you've served, and the costs are assessed. When you get out, you will be on post-release control to the parole authority for at least a year, up to 3 years. They'll place conditions on you. If you violate the conditions, they could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. If your violation is a new felony, then you could get an additional consecutive prison sentence for the violation, the maximum of which would be the greater of 12 months or the time left under post-release control. Anything further, Ms. Cutts?
No, thank you, Your Honor.
Mr. Mulkey?
No, Your Honor, thank you.
All rise.
Alrighty, friends, about halfway through TCF Live on this beautiful Thursday. So glad you're all here with me today. If you have not yet done so, do take a moment, say hello to us in the chat, especially if you're new here. This is the best community in LawTube. We're a friendly folk. We don't bite, generally, so do say hi. Let's do this. Let's go down to Texas, check in with Judge Stevens, who looks like he had his hair did since yesterday.
Spanish-speaking judge?
You're the judge. He's Spanish speaking.
Oh, do you speak English? Sí. Muy poquito.
Judge, this is one where.
Le pregunto que cómo está.
Buenos días. Muchas gracias.
This is one we were waiting on a report from Dr. Grapon. I really hoped we were going to have it today, but we do not. If we could please come back in 4 weeks, I'll get that report to Nisha. She's also not good. She's in training. She needs training.
No.
Oh, I understand, Judge. But, I mean, I'm the second year old, and it's all kinds of challenges.
Who's on this one?
Tanisha.
Tanisha?
Oh, good.
I knew if she was here, she would say,
no, we object.
But she's not here.
He's not here, so we don't care.
Right.
Just say to reset 4 weeks. I'll get the report to the prosecutor. Hopefully we can get this solved.
Good. Done. Anything else? Mrs. Moore?
Good to see you, Rogelio. I'll leave it there.
Hasta luego.
Awesome.
We'll leave it there too.
So,
Okay, Troy.
yes, sir. That's up to
Steins.
you.
We got a disposition here?
Yes. Dismissing the old indictment, and they filed a new one on one of those weird hybrid felonies on the transportation case. Deferred on that.
Okay, so we're moving forward on 26 CR 1468.
Yes.
2045 will be dismissed.
Yes, sir. Oh, let's go.
And you are Troy Gildenstein.
This just says I got all of it.
Here with Mr. Pritchard, your attorney, and the state's attorney.
Sir?
Does the defendant waive the normal reading of the indictment and arraignment here in 26 CR 1468? Can we proceed in summary?
We may, Your Honor.
In summary, sir, this indictment alleges that on or about October 6th, 2023, in Jefferson County, Texas, you committed the third-degree felony of collision involving, I guess, an automobile involving an injury. Do you understand what you are charged with here?
Yes, sir. And Judge, it's not technically a third degree. It's
So it's classified as a third degree under the Code of Criminal Procedure.
Oh,
If it has
yes.
penitentiary punishment attached to it.
Okay, but the punishment range under the Transportation Code is up to 5 years TDC or as many as the county jail.
Mm-hmm.
So it's not up to 10. I just wanted to clarify. So I checked.
Is that, how's that?
Check the blank.
Do you feel better about getting that off your chest?
I thought that's really good enough.
Oh. You understand what you're charged with here, sir? And because this carries with it up to 5 years in prison, as well as it could be also for 1 year, up to 1 year in the county jail, this is considered a third degree felony under law. And do you understand?
Yes, sir.
Also, it's up to 5 years to these. Is there a fine?
Up to $5,000.
Is it? It's not 10,000. It's
No,
not
up to 5,000.
Okay.
Good, so.
And this, for 1 year in the county jail, I guess that carries with it up to $2,000 fine as well, right? Does it?
No, it's still the $5,000 is the fine. It's a transportation code thing, so that's why it's outside the Code of Criminal Procedure. It's bizarre.
It's a third degree felony.
Yes, sir.
At the end of the day, when.
Yeah, exactly.
An agreement's been reached where you would be pleading guilty, but not found guilty. You would be placed on deferred or unadjudicated probation so long as you follow the terms and conditions of probation that the probation officer is going to prepare. And there are like 35 terms and conditions, but the overwhelming majority are those, the same kind of things that he has to follow.
Yes, sir.
And as well as I do, and as well as Mr. Led, like don't commit a crime, take care of business. And so you can do this. Have you ever been in trouble for?
No, sir.
Fix this. It's fixable.
No, yes,
Do
sir.
it. You can do it. Okay.
I'm good there.
Good for you. So you would be placed on deferred or unadjudicated probation, which can be up to 10 years in length. And restitution is ordered. This is in an amount of $100,000. All right. How are you going to pay that? At one lump sum or a little bit at a time? Okay. How much are you able to pay monthly?
About 1,000.
Sir?
About 1,000.
Okay.
I told him with fees and everything, it would be around 1,000.
So, yeah, that's 12,000 a year times 8.5. That gets you up to
Yes, sir.
where that would deplete the 100,000.
Yes, sir.
Oh, do. Also, another case, 23 CR 2045 would be dismissed. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
First thing I'm going to show you is what's called State's Exhibit 1. Did you sign that, understand it, discuss it with your attorney? Here, sign it. You hadn't signed it yet.
Oh,
At the bottom. But I'm sure you discussed it with your attorney.
Yes, sir.
And he's gone over it with you. Is everything true and correct
Yes, Your Honor.
Right. State's Exhibit 1 is tendered into evidence and without objection.
No objection.
Yeah, admitted. Among other things, it states you are mentally competent to enter your guilty plea. It's freely and voluntarily. Do you know what you've been charged with? The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You're giving up your rights to a jury trial and the rights of the appearance, confrontation, cross-examination of witnesses.
Yes, Your Honor.
Totally satisfied with the representation provided by your lawyer.
Absolutely, Your Honor.
You want to think a little? You've considered long enough, and that's your final answer?
Yes, sir.
State's Exhibit 1 is a part of the record for all purposes. Pre-sentence report is waived here.
Yes, sir.
I'm going to follow this agreement, sir, and find that you are mentally competent to enter into this agreement. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But
Yes, Your Honor.
I'm going to defer all finding of guilt. So long as you follow these terms and conditions of probation, make sure you go over them with the probation officer, and also anything you don't understand, ask questions, but also Mr. Crenshaw is going to guide you through all of this. Make sure you follow these. And we dismiss deferred probations early for good behavior. Okay? So we reward it. If you fail, I hate to say that, if you fail, your probation can be revoked. You can then be found guilty of a felony and sentenced up to 5 years in prison, which you don't want to stay up late worrying about.
Yes, sir.
So just do it. And like I say, most of these conditions, these requirements are the kinds of things all of us have to follow. Also, we're going to add, you have to take and pass defensive driving course, which is a win-win. It's a requirement.
Yes, sir.
Plus, your insurance will go down.
Yes, sir.
You got that going for you. Please see the probation officer. Make sure you understand everything. Sign it, and the quicker you begin, the quicker you end. Good luck. All right.
Thank you, Judge.
Thank you. And there's a dismissal here coming up, right? Great. Oh, sure.
This one, you're right. That's you can say. Sounds good. Yeah, sure. I'm actually talking here. So much cooking, where we're going to
All right, friends, I'll keep an eye on Judge Stevens' court. At some point, we'll rack up another contestant there. But in the meantime, back once again to Judge O'Donnell, new contestant in Ohio.
Their evaluations, the state's understanding, all evaluations have been concluded, including the drug and alcohol, have been provided to the court, and then all parties are prepared to go to sentencing at this time.
How many days are there on 623?
On 623, there are 104 days.
And what about the other case?
759 is 70 days. They are not separate and distinct days. Those 70 days overlap both cases.
All right, Ms. Thomas.
Yes, thank you, Your Honor. We would like to ask the court today for an opportunity to place Mr. Caudill on community control sanctions with treatment. Your Honor, in speaking with Mr. Caudill, he is currently on probation with Ashtabula from a 2022 case. He did do NeoCap through there, so he has done some form of treatment. Mr. Caudill indicated he really did enjoy NeoCap. However, he indicated he does need a little more help when it comes to drug treatment. Your Honor, he would like to ask the court today for an opportunity to do the jail treatment program. He is also on the wait list for Lake Geauga. He is also open to any additional treatment. He indicated he does have a great support system at home with his fiance. Your Honor, while in the jail, he has been very productive. He's been doing AA and NA meetings. He has been going to church. He did start a prayer group in the jail. He did receive his 90-day chip from his NA meetings while being in the jail. So Mr. Caudill is taking this very seriously. He is being very productive in the jail. He's trying to start his treatment. So, Your Honor, we would just like to ask the court today for an opportunity with community control. Thank you.
All right, Mr. Caudill, what do you want to say?
I would like to first start off by apologizing to you and apologizing to the prosecutor. I'd like to apologize to my sister because my life isn't the only life that I've affected. I want to let you know that I've come to the realization that I know that I have a problem. Yes, I was in NeoCap. Whenever I was in NeoCap, I didn't enjoy it. They taught me more or less how to change my way of thinking. They never taught me how to help with my addiction disease. They taught me cognitive thinking, thinking for a change, and all that good stuff. They never had meetings. They never had no support groups or anything like that. So I never really got able to, or I was never able to have the chance 2, experience the actual support groups or the actual meetings or the actual help of the disease of addiction. I would just like to say that I've taken accountability for my actions. I realize that I do have a problem, and I would like to take care of my problem in the best way, shape, or form. I just ask that you see that, and yeah, I'm sorry.
You were placed on intervention in Ashtabula.
Yes, sir.
When?
In 2022.
Did you get violated and get convicted of that offense?
I was violated only because whenever I got out of NeoCap, me and my daughter's mother, we ended up splitting up, and I was forced to move out to Madison to my father's
Was the
house.
intervention terminated?
Oh, I'm sorry. No, it was not terminated, sir.
So you're still on intervention?
I do believe so.
So nobody seems to know. We can't tell from the Ashtabula docket. So did you disappear from Ashtabula and stop reporting?
No, I reported that I was moving to Madison, and my Ashtabula probation officer was not okay with that, but I had no other choice at the time. I had nowhere else to go, so I had to move out to Madison to my father's house. And at that time, as whenever I got violated.
Violated for what?
For failure to report my address change.
Okay.
And my daughter's mother at the time, my daughter's mother at the time was my only transportation, so I lost transportation and was not able to report.
So you didn't report?
No.
Okay, that's what I asked you. Did you stop reporting?
I'm sorry.
Okay. So how do you comply with probation if you don't report?
I was complying to my fullest degree.
When did you go to Lake Area Recovery Center?
Lake Area Recovery Center?
Lake Area Recovery
large?
Center.
That was after NeoCap, Your Honor.
Okay, what did you go there for?
For IOP.
Okay. When did you complete it?
No, that's in the process of me whenever I had to move out to Madison.
Okay. Why didn't you complete it?
Because I had to move out to Madison and lost transportation.
Why did you have to move to Madison?
Because I had no other place to live after me and my daughter's mother broke up. We were living
Why not?
together. I had nowhere else to go.
Weren't you working?
Yes, I was.
Doing what?
Working at RTS in Austinburg.
Okay. So why didn't you get an apartment in Ashtabula County or something?
I didn't have enough money, Your Honor.
Okay. All right. So they didn't treat you for the drug stuff at NeoCap, which is your complaint about NeoCap.
Yes, sir.
And so you got the opportunity for drug treatment at Lark, and you left.
Yes, Your Honor.
Okay. And then you pick up, you get this OVI here. You got drugs on you. What drug?
Meth.
Meth. You stick a pipe in your ass, try to sneak it into the jail with meth in it, right? Why did you do that?
I was scared by the time I realized that I had it in my pants. I was scared. I didn't know what else to do. And whenever they put me through the scanner, they asked me about it, and I told the COs that I had it.
Okay.
I wasn't trying to intentionally sneak anything into the jail, Your Honor.
Well, you were, because if you weren't, then you would have said before you got in, I got this, okay? So you were. You were trying to sneak it in. So you haven't demonstrated that you're interested or you have the ability to solve your problem. In the short time that you've been involved with the system on a felony level, you've demonstrated the opposite of that. And you didn't really have an OVI, you were just tired, right?
Yes, sir.
So maybe I wasn't here. Was I here when he pled guilty to the OVI?
That is my understanding, Your Honor.
Okay. Well, you didn't commit an OVI?
No, sir.
No. Jeez. You should. Why did you plead guilty?
Because I just wanted to take responsibility for my actions, Your Honor.
Well, you wanted to take responsibility for drunk driving when you weren't drunk?
No, but I didn't.
Why did you get out of the car and leave your sister in the car?
I didn't leave her in the car, Your Honor,
Okay. Why did you get out of the car and leave?
because I had no license and I was scared.
Okay.
I was scared
And
to
where
take
was your
respons-
sister?
She was with me. I was scared to take responsibility for my actions at that time, Your
No,
Honor.
no. Where was your sister?
She was with me.
So the two of you left together?
Yes, Your Honor.
Okay. Whose car was it?
It was my car.
Okay. Is it registered in your name?
No.
Well, then it's not your car.
Well,
Whose car is it?
It was a girl that I was friends with. She purchased the car and put it in her name. I signed the title. The title signed over into my name.
When?
2 days before I got in my car accident.
So it was registered in your name?
It was just signed over to me.
Okay. So the answer is yes, it was registered in your name.
Yes.
How, did you think that the cops weren't going to find the car?
I knew that
And
they were
trace
going
it back to whose car it was?
I knew they were going to, Your Honor.
See, now I don't believe you. When did you get caught? Same night?
Yes, sir.
And you had meth on you?
Yes, sir.
Okay. But you weren't under the influence?
No, sir.
Jeez, oh man. This is a day when that seat is telling stories. Why would I believe that? Why in the world would I ever believe that? Okay, you go to NeoCap and it helped you with thinking, but it didn't, you complained it didn't help your drug treatment, so they send you to LARC. You leave LARC because you have no place to go in Ashtabula County, only in Madison. You get this car accident where you hit a pole and you got meth on you, you leave, but you weren't under the influence, right? So tell me, in this whole scenario, what exactly, and you weren't trying to sneak the pipe into the jail, tell me in this entire situation, what exactly are you responsible for?
I'm responsible for everything that happened that night, Your Honor.
Okay, which is nothing because you didn't really do anything because you weren't under the influence.
I had possession of methamphetamines. I did have possession of the pipe.
How long have you been carrying the methamphetamine around?
About 6 months, 7 months.
6 months. Why were you carrying meth around with
Well,
you
not,
for 6
not
months?
the same bag. I was using meth at the time.
Okay. You were using meth for 6 months?
Yes, sir.
Okay, but you weren't under the influence that night?
I wasn't high for a few days. That's why I fell asleep.
You weren't high for a few days?
No.
Why were you carrying meth with you if you hadn't used for a few days?
Because I was willing to use.
Okay. See, you have this aversion to the truth that isn't serving you very well. Did it take you 100 days sitting over there to think up all this nonsense you were going to tell me?
No, Your Honor.
You just off the cuff? Or is it the truth?
It's the truth.
Okay, it ain't the truth. It's everything except the truth. When is the last time you had contact with the Ashtabula probation officer?
I want to say February or March of last year.
Okay. February or March of 25. Is that when you moved to Madison?
Yes, Your Honor.
Okay. All right. What do you think they're going to do with your case?
I'm not sure.
Yeah. I can imagine. I'm not sure either, but I can imagine. Anything else you want to tell me?
No, Your Honor.
Ms. Cutts?
Thank you, Your Honor. These cases involve, as this court is aware, a single car accident where the defendant was the driver and his sister was also in the vehicle. According to the police reports, even the pre-sentence report that included the defendant's written as well as his interview, it indicates that he left his sister in the car when he fled. When he was located that same evening, he had methamphetamine on him. Through reports and other information, we learned later that while he was in the police car, he put the pipe into his buttocks. When he was taken into the jail, he did not tell anybody. There were a few scans done when finally it was noticed that something was wrong, and that was then recovered. The pipe did have methamphetamine on it as well. So these two cases encompass that time frame of March 18th of 2026. In this case, though there is an argument there's not a victim, there is also an argument that his sister would be considered a victim, and I would imagine, having siblings as well, that having somebody crash and then leave you in the car would have some sort
He didn't leave her in the car. She got out with him.
Not according to everything else, but either way.
Well, I'm just going from
Understood.
what I hear today.
Either way, whether he took her or didn't take her, that would have an impact on her psychologically or emotionally. He does have a history of criminal convictions. In 2016, he has conviction for open container. In 2023, for possessing drug paraphernalia. It's a little unclear. It looks like the conviction for aggravated possession of drugs, the F5 that we've been talking about in Ashtabula County, occurred in 2022. It seems to be notated as conviction in 2024, so it is a little unclear. He's at least been under supervision with them on intervention in lieu of conviction for an extended period of time. The information I received from our probation department that they received from Ashtabula's probation officer was that the defendant has not been compliant since the beginning of supervision, that he has violated, and there have been new charges, that he initially in March of 2024 had a violation for testing positive, for not completing LARC, for not entering treatment and turning point, and also, and then eventually was sent to NeoCap. In November of 2024, he tested positive for marijuana on 3 different occasions. In December of 2024, he failed to report to probation. He was not compliant with treatment. He tested positive for amphetamines and marijuana. And then in January of 2025, he failed to report to probation, and that's when he failed to provide an updated address. So that probation violation warrant went out in February of 2025 and is still pending. So he was not in compliance with them from the beginning. He does have a warrant for that probation violation, as well as a failure to appear warrant for obstructing official business out of Ashtabula Municipal Court. In his traffic offenses, he also has failure to appear and probation violations. He has had treatment opportunities in the past where he's not been compliant, where he's either failed to appear or tested positive. So he has not responded favorably to previous sanctions, and there has been some difference in information as to when he was using methamphetamine, depending on who he talked to. So based on all of that, the state does feel that he is not amenable to community control and that prison is consistent. He has 104 days credit in case 623, depending on how the court chooses to sentence him. He has 70 days under 759. Those are all included in the 104 days he has in the other case. The OVI in case 623 does require mandatory 3 days in jail or the DIP program, as well as a mandatory fine and mandatory driver's license suspension. There are forfeitures in both cases, so we would ask for the forfeitures and costs, and that would be the state's recommendation.
What's the fine range on the OVI?
$565 up to $1,075.
And then it's a 1 to 3?
Correct, for the license suspension.
All right. I reviewed the pre-sentence report and the evaluation. I've considered all the provisions in 29, 29, 11, 12, and 13. It's clear whether it's a violation of intervention that is 3 days in jail, which will be concurrent, $575 mandatory fine, and a 3-year license suspension, and the costs are assessed. And the items subject to forfeiture are forfeited on 759, 12 months in prison, credit for 70 days. That'll be concurrent to 623, and the costs are assessed. The items subject to forfeiture are forfeited. When you get out, you might be on post-release control for up to 2 years under the parole authority with conditions. If you violate, the parole authority could return you to prison for up to 6 months. If the violation's a new felony, you could get an additional consecutive prison sentence for the violation, the maximum of which is the greater of 12 months or the time left under post-release control. Anything further, Ms. Cutts?
No, thank you, Your Honor.
Ms. Tomasic?
No, Your Honor, thank you.
All rise.
All right, kids, sing along with me now. If you put something in your ass, you're gonna get prison. If you put something in your ass, you're gonna go away. And then you guys can pick it up from there. Alrighty, back to Judge Stevens.
And you? Yeah, you're familiar. I've seen you here.
Morning, Judge.
I guess we saw you here last month, July, in July. 9th. Okay. Okay. What are we doing today?
Judge, we have discussed a counter offer with Mr. Coleman. If we could have a week to consider that because it is a town offer.
How you doing, buddy?
Good morning, Your Honor.
Nice outfit.
Thank you, Judge.
Okay.
You as well.
Yeah, thank you. Go ahead.
Thank you. Go ahead.
All right. That was weird. Okay.
Which part?
Here he comes.
Just-
What? You're back?
Mr. Laird ran out the back. He knew I was chasing him.
Oh, you don't have the key to get out?
I don't know if that's public, but I don't.
Everybody else has one. Okay.
I read one.
All right, Tom.
Yeah.
You, 1 week?
Yes, Judge.
And then what, we gonna try to dispose it in a week?
We're attempting to do, yes, Judge.
Is,
We will
what are the
know.
odds? Good. You're looking around, that's not a good sign. When you do it.
You stay, come down on its offer, Judge. We're attempting, we're working, trying to work it out.
Tommy, ask me something. Are you guilty or not? Say,
Not guilty, Judge.
no, ask me.
Are you guilty, sir?
That's what she did just there.
Tired of your hair, Judge.
Well, she did real well on the left hair. It's the right hair. That's making fun of that. All right, 1 week.
Looks nice.
Thank you.
Thank you, Judge.
You know how long this hairpiece took to glue on? I'm just kidding out there, everybody. When I was, my youngest daughter, Allison, she goes, one time she said, then she was like 4 or 5. She said, Dad, you're losing your hair. And I told her, honey, there's an old saying, grass doesn't grow on a busy street. And she thought, and I mean, like 5 seconds later, she goes, it doesn't grow on concrete either. And my wife tells that story all the time.
It's a good.
Yeah, it's funny. Now Allison runs hospitals. She's administrator of hospitals in Houston. I guess she was a smart kid. Must have gotten that from her mom. Okay, Antonio Landria.
While we wait for the next contestant to come up, this slipped through as I'm looking through my show notes here that I've taken. Earlier today, Gigi, you gifted 5 memberships, and I never thanked you for that. So apologies, and thank you very much. I appreciate it.
CR274 is called. Is it Tamia? Tamia. Okay. Thomas. And you were here with Mr. Naldi, and as you know, you are charged with a state jail felony of operating a motor vehicle while intoxicated with a child passenger, which can carry with it up to 2 years in the state jail, and it's a felony. If you don't want any of that, what are we doing today?
Judge, she has expressed to me that she will be hiring out of Alvin.
Well, it's about, you can do that, but this right now is 16 months old. That's too old. How long is it going to take for you to, it was indicted in February of 25. Well, I'm sorry you know about that, but it was indicted. It's old. How long have you been in the free world? Months?
Been working with her, but I didn't hear you, man. So I've been working with her, but we finally got an offer, I think a month ago. Finally had a fun conversation, and I didn't like what I was told, so.
I'm sorry, but okay, but you can hire some, if you're able to hire somebody, I mean, she was appointed to represent you, right? Well, are you able to hire somebody?
My dad is hiring me, so.
Okay, somebody's gonna, well, we're not gonna wait around. Then you don't want to represent yourself, but this is too old. And You don't get to set the time, and this, and she's a fine lawyer. But you can choose somebody you want, but we're not going to wait on you. Okay? I'm going to give you 3 weeks. That's what you have. And at 3 weeks, we fish or cut bait. We try it or not. Okay? All right. Thank you. Get a resetting. Let's make sure she knows if you hire somebody so that she doesn't, she's busy on a lot of other things, and everybody appreciates her work, and she doesn't need to waste time if you're going to have somebody else on your case. Okay? Chris Price. Chris Price, Mr. Morgan? Yes, sir. Is it you? Okay.
Good morning, yeah.
Good morning, guys. Yeah.
Okay.
Hey.
Oh, Pamela eBay. Yeah, MALASIBEH. Yeah, I believe I already been sworn.
You were
last time for this case.
And Rebecca Walton was the prosecutor, right?
That's the VA,
Okay.
and I'm the assistant.
Okay. Hey, who are you?
I'm Matt Morgan.
Oh, give Mr. Morgan.
Yes, sir.
Okay. We have 2 lawyers though representing him, right?
No.
What? Not anymore. It's not
So
just.
Mr. Crenshaw was on this case. I've taken it over. Mr. Price has hired me, of course, and then the state, the DA's office in Hardin County has been appointed.
Okay.
That is correct.
All right. So you were here as a special prosecutor?
Yes, sir.
Okay, from Hardin County.
Yes,
Okay.
sir.
Great. All right. That's welcome.
Thank you.
There you go. I see you, Pam.
Yes, sir.
Okay. As you know, you're Chris Price. As you know, you're charged with this Class A misdemeanor of official oppression, which I guess carries with it a normal Class A misdemeanor punishment up to 1 year in the county jail and or fine up to $4,000. All right. What are we doing today?
Your Honor, this is our second appearance with Miss Eve and I. This is a case that's got a pretty large amount, a decent large amount of discovery. I have received it at this point. I don't believe that I'm missing anything. However, we are still combing through it. And Ms. Pam and I have been visiting about this case, and we would just ask that it get reset, Your Honor.
How much time before we can fish or cut the bait? What direction? When am I going to know what direction they're going? 4 weeks?
That's fine, Your Honor.
In 4 weeks? Y'all think y'all be ready to make a decision?
Is this August, September? That's fine. Yes, Your Honor.
Yeah. It was indicted in March. Okay.
Sure. And I'll just put the court on notice that I've got, and I don't want to move this around to accommodate these. I've got about 3 jury trials set in the next couple of months, and they're up in the air whether they're going.
Have you tried 618? Because I have.
Yes, sir. I just wanted to put the court on notice. I don't want to not set this, on that date, because I know in September we got 2 set, but I'll let everybody know as soon as I know if I'm going or not.
Okay.
That sounds good.
Okay, so what's our final answers? We said it to
just 4 weeks, Judge. That's
4 weeks.
Yes,
Okay, great. Thank you. Resetting. Thank you.
Again, thank you.
Yeah.
Hour 3 of TCF Live, friends. I want to go back up to Michigan and check in with Judge Aquilina. Here's the thing. There's a defendant here, and there are 3 sheriff's deputies currently guarding him, and normally in this courtroom there's 1. So I've got no idea what's going on, no idea what this is about, but what catches my attention is the amount of security around this guy. So let's see what it's all about.
6. Let me print that throughout. All right, that would be on the sentencing, basic information sheet on both counts. And I corrected the cover page. Does he receive any additional jail credit based on change of date?
Yes, Your Honor, and I was gonna get into that next.
So let me change that one going through everything else.
So
is that through today's date?
It's a little bit different, Your Honor, because he was sentenced to MDOC. What we have calculated, so the initial arrest portion should be the same. For the the next section that's bond revoked, that should be from March 25, 2026 to June 4th, 2026, when he was ultimately sentenced on his MDOC case.
June 4th, 2026?
Correct.
So I'm getting rid of the December to the May.
Correct. It should be March to June.
Okay, and how many days is that?
That is 72 days, Your Honor.
So he would only have the 72 plus the 39?
There is an additional section as well, Your Honor. So he was supposed to be sentenced on June 26th of this year. However, due to the court's availability, we were unable to get to the sentencing that day, and you had told both me as well as the defense that you would start counting credit on him from June 26th to today.
Is it the 26th or the?
June 26th.
Okay, so not the May 27th?
No.
Okay, June 26th?
Yes,
Okay.
June 26th to August 6th today, which would be 42 days.
So what's the total?
153.
Both of you agree?
Yes.
Changing on the cover page, I will change on the basic information sheet.
That's also the evaluation plan.
Yes, end of the first paragraph in the evaluation plan, the jail credit and the sentencing date are listed.
And I'm changing that as 21 in the recommendations. Changing on the evaluation plan. What was the date? And then going to the instant offense.
And just to be clear, Your Honor, that's another change that we need to make.
Okay.
The instant offense is actually 4 of 5.
Okay. So then what's above it? Because instant offense says 5 of 5, right?
Yeah, so the instant offense would actually be 4 of 5. 5 of 5 is the Eaton County case that he's currently serving his sentence on.
Oh, I got you. So do we need to correct that box? Because it says, I think, pending.
Yes, so that would need to be changed from pending to instant offense.
Okay.
And then for 5 of 5, that should say, in regards to the disposition sentence, that he was sentenced to the Michigan Department of Corrections to 15 to 72 months.
Okay. So I changed our sentencing date and instant offense, then we're good on that. All right, and I think I've got all of those other corrections. What other corrections are there?
That are all the corrections that the people have to the body.
On behalf of defendant, any additional corrections?
On behalf of defendant for the body of the report, Your Honor, I believe the only thing left that I would like to correct is on the basic information report, first page, number of prior felony convictions. Prior to this conviction, he didn't have any other felony convictions. I don't think that the Eaton County ones happened in time after this one was committed.
So the cover page indicates 0 felonies and 4 misdemeanors, and so the basic information should be the same.
And I would agree with that, Your Honor.
All right, so let me get to that section. So I'm actually not seeing what box that's on.
So it is, Your Honor, on the basic information near the bottom, it says number of prior felony convictions, and that says
On the first page?
on the first page of the basic information.
Under criminal history, right?
Yes, the criminal history.
Oh, number, so it should be 0, I see.
Yes.
So by the corner, I didn't see it, okay.
And it
got
does reflect that correctly on page 1 of, the pre-sentence report.
I guess that.
It also should say that he's a current Michigan prisoner under sentence there. Put yes for both of those instead of no.
And that's on the cover sheet, Your Honor.
Yep.
Okay, just a minute, so where are you referring to?
Under prior records,
Yeah.
a current Michigan prisoner says
No,
no.
this is, yeah, it should be yes, and yes.
That's it, Your Honor.
Okay, all right, how about the guidelines?
Yes, Your Honor, the only change that I have is in regards to OV12. OV12 is currently scored at 5 points, and OV12 is for concurrent contemporaneous felonious criminal acts. It is currently scored at 5 points. However, Your Honor, we had dismissed 2 crimes against people, that being resisting obstructing a police officer and attempting disarming a police officer, both of which are people crimes, which would make OV12 scored at 10, which states 2 contemporaneous felonious criminal acts involving crimes against a person were committed. And that would be on both the resisting and obstructing sentencing guidelines as well as the retail products guidelines.
Thank you. As to OV12 being 10, counsel?
No objection.
OV12 is 10 and both. That changes unless there's any other corrections.
No, Your Honor, and that does not change the level or the guidelines.
So the total OV is going to be 30 and 40. So that would be 30 on the retail fraud first, and on the police officer assaulting would be 40. It's 5 graders, right? So let me change that to basic information sheet. So they had it wrong on the basic information sheet as well. They had 35 and 35, but it's not. Now it's 40 and it's 30. So they had it wrong. Look at that. Okay, so we don't need to correct that. So count 1 is 30, the total is, or no. The OV, so they had it right. Okay, I had it wrong. Okay, so the OVs are 30 and 40. The other ones are right, 35 and 35. Sorry. The wrong column. Okay, so are we good?
Yes, Your Honor.
Yes.
Okay. And is there a victim who wishes to address the court in regard to Mr. Gramsa?
No, Your Honor.
On behalf of the people, what would you like me to know?
Yes, Your Honor. Probation ultimately asked for Mr. Gramsa to serve a probation sentence.
I'm not going to do that.
And obviously that doesn't quite make a lot of sense since he's going to be an MDOC for the Eaton County case. And in the Killebrew, there was a agreement for the sentence to run concurrent. So I would just ask for a sentence that would run concurrent to the Eaton County case. And as I had stated, just to remind Your Honor, the sentence on that case I have is 15 to 72 months. Thank you.
Thank you. And I see that the police recovered $1,085.63 of merchandise that was stolen from Myers. So is there restitution? I don't see anything here.
There is not, Your Honor. It was all recovered.
Okay, very good. Thank you. And what about in terms of law enforcement? No injuries?
No injuries, and the police requested from our office in regards to restitution, Your Honor.
All right, thank you. Counsel?
Thank you, Your Honor. Yes, we asked the court to find a client and sentence him to a concurrent term in the Michigan Department of Corrections. His earliest release date he could be eligible for parole is March 12th of next year, Your Honor. Thank you.
All right, thank you. Sir, what would you like me to know?
I guess that, like, I definitely made mistakes and that I'm trying to right my life and go in the right direction. Definitely sorry for the choices that I've made.
Sir, you are not the worst criminal I have seen. And your record is fairly minor. I mean, you have some bad things. You've got some domestic violence and assaulting, resisting, breaking, and entering. But it has to stop now because I'm assuming you don't like, I don't want to assume it, assuming you don't like prison.
No, not really wrong.
Well, can you imagine being there the rest of your life?
I wouldn't even want to imagine it.
Well, think about that while you're there. You have got to turn a corner and decide to treat your family, your community, and yourself with respect. Because otherwise you're gonna be locked up for the rest of your life. If it's not locked up for the rest of your life, it'll be in a body bag. I mean, there's a fork in the road, and there's the path of rehabilitation and hard work and earning respect and earning a good wage and having all the things you want through your own efforts. And then there's the path where you cause pain and mayhem in your community and also to yourself, and you end up in a body bag, in jail, and then in prison. There's just no gray area for you anymore because this record is pretty awful. And so Eaton County decided to send you to prison. They got you before I did. So I'm also going to send you to prison and run this concurrent, but I don't have to. That's their agreement. I could do this consecutive. But I do believe in rehabilitation. So avail yourself of that in prison. There are programs. Figure out why you're so angry at the world. Do you know? Because this speaks to drugs and anger, real unhappiness. Have you figured out what's bugging you?
Not at this point.
Have you even thought about it like that? No, you haven't. Where are your parents?
Perry.
Do you have a relationship with them?
I talk to him every day.
I'm sorry, I didn't hear you.
I talk to him every day.
So you're really lucky. A lot of people I see, either their parents are addicted to drugs, left them, or they're dead. So you have parents who care about you and are going to be there when you're out. So ask for help. That is a sign of growth, maturity, healing. It is not a sign of weakness, it's a sign of strength. But you have to do the work, they can't do it for you. So what about treatment? Are you in treatment in prison for your addiction? Because you've got marijuana, opiates, it's like morphine, heroin, codeine. I don't know what you were taking exactly, but alcohol, meth messes with your brain.
I have to take a class.
Have you started it?
Not yet. I just got transferred over to STF, Central Michigan Correctional Facility.
So how are you doing without the drugs?
Coping. you know, like, growing, moving on, you know, just trying to figure out how to get my life back on track, you know.
Well, sir, you need, I can only recommend to the warden, okay? But I'm going to recommend treatment because you need not just substance abuse treatment, you need some mental health treatment and counseling. You've got to figure out what you are shoving down with alcohol and drugs and criminality and why you're so angry. So if you don't figure it out, it becomes a merry-go-round until it stops in prison, or the body bag I talked about. You have got a lot of self-reflection to do, figuring it out. Whatever happened to you, whatever someone said to you or did to you when you were younger, it's coming out. And you're paying the price for it. Deal with it. There are people who can help you, including your parents. Sir, as to count one, the retail fraud first degree, you're going to get 14 months. 14 months to 60 months with credit for 153 days. As to count two, you'll get 14 months to 24 months with credit of 153 days. While you are incarcerated, you will participate in substance abuse counseling and treatment. You'll attend AA, NACA. You'll also see a mental health professional for counseling, one-on-one and group, if it's available, and I believe it is. They do a much better job than they've ever done. And so you need to get real honest with your therapist and yourself. Figure this out.
Sure.
Because if you don't think the judges and law enforcement have your number, it's all here. Myers keeps footage. They know who we are too. I don't know who else you've heard, but they all know who we are. So if you think you can continue this and hide, there's no more hiding. You will pay $136 state cost, and you will pay $130 crime victims. So that's a total of $266. That will not be due until 24 months after your release.
Yes, sir.
So that way they don't assess late charges and all of that.
Yes, sir.
All right? Because you'll have to pay it. I get it from you one way or the other, and you need to start paying it as soon as you can because it's just going to grow, and they'll get the money no matter what.
No, for sure.
Okay? All right. And what is your line of work?
Carpenter.
Carpenter?
Yes, sir.
So you have some skills. You could retire a very wealthy man if you put those to work.
I already have I'm fully vested in my pension. Got my 401k already set up and stuff, so.
But you gotta earn some money, and you're gonna be locked up and can't fill that pension.
No, for sure.
So when you get out, be lawful, there's lots of business. When I need a carpenter, I have to wait 3, 4, 5, 6 months. Half the time they don't show up, I gotta find a different one. I'm not the only one. There's lots of work out there for you. And the skilled trades are the next millionaires, because there's a shortage. So what are you doing with all this? Figure it out, sir.
Yes, sir.
This is really conduct unbecoming, and you're degrading yourself.
Sorry.
All right. Anything else I need to order for him that I haven't?
I just want to confirm, did you state that the sentence is concurrent with the Eaton
Concurrent
County?
with Eaton County, yep.
Okay. just wanted to
Concurrent
make
with each
sure.
other and Eaton County.
Nothing additional than there, thank you.
Sir, Sir, it's really not gonna be dependent, it looks like, on my sentence, it's gonna be dependent on whatever Eaton County did, because I gave you a bit of a shorter sentence. Plus you've got some credit days, so I didn't make it worse for you.
I was just trying to do the math and do know.
You know, jail and prison math is just not like normal math. You get credit for this, that, and the other thing, and then if you have a fight or a ticket, there's lots of things they do, so I'm sure there's somebody in the prison that can help you sort it out. You have 42 days to appeal and to request appellate counsel.
Yes, Your Honor, I will provide that form.
Sir, someday when you get out, come back and show me the great things you've done. I'd love to see your carpentry. Maybe I have a job for you too. There's a shortage of people like you. Climb the mountain of success. Don't drop to your demise. I'd like to.
Thank you, Your Honor.
Now in the final half hour of TCF Live, I hope you're all enjoying the show today. Let's go to Louisiana. Let's check in with the board.
Good morning. Committee on Parole is called to order. Today's date is August 6, 2026. The time is 9:06. My name is Chuck Tillis, and I'll be serving as chair today for this committee. My colleagues are on Zoom, Ms. Jerry Ledoux and Mr. Steve Prater. We're located at the DOC office here in Baton Rouge, Louisiana. Staff, would you please introduce yourself for the record?
Marla Williams.
Thank you. Our remote location is at Orleans Parish. Is any staff there? Would they introduce themselves for the record, please? Can you hear us?
No, yeah, I can hear. Speak about it.
We can.
I was listening to see when you couldn't on. Yes, how you doing?
Yeah, when they asked the staff to, they're gone. Would you give your name and DOC number for?
Alvin Clay, and my DOC number is 496229.
Okay, Mr. Clay. We have Steve Prater is going to be handling your case today. Mr. Prater, are you prepared?
Yes, I'm prepared and ready to go. Mr. Clay, you're represented by David Wolfenson, is that correct?
Yes, sir.
And I see Mr. Wolfenson is on the air with us.
Good morning.
Good morning. And I think he has a statement to make. If that would be appropriate, Mr. Wolfenson, you sent in a late request, and I'd like you to address that before we waste any more time with this hearing.
Absolutely. Thank you. And for the record, this is David Wolfenson. I represent Mr. Clay. I am requesting a continuance of today's proceedings. I was not originally the attorney assigned to Mr. Clay's case, and so I did not become aware that this hearing was going to occur today until last week when I was out of town. I received a call from Mr. Clay. I went and saw him on Monday when he let me know that this was going to be happening. I reached out to the board, the administrative office on Tuesday, got all of the associated letters, things of that nature. But because I did not know that this proceeding was going to be happening today, I am requesting a brief continuance of this matter just so that I can work on getting some things together so that I can actually present full case on Mr. Clay's behalf to the board.
Mr. Wolfson, I appreciate that. It sounds reasonable. I would like to ask something though. Has his case not been handled by, quote, we'll call it a firm, by the Indigent Defender's Office, Public Defender's Office of Orleans Parish the entire 3 years he'd been awaiting trial?
That is correct. And so I do not know I don't know why the case has not appeared yet at this proceeding. I don't know. There was nothing in the information that I received when I received the case that there were scheduled dates or anything of that nature. And so I apologize for myself and on behalf of anybody else. And I can tell you that this will be the first and last request.
Okay. Well, I appreciate that. We'll consider this the last one because, quite honest, the defendant shouldn't have to call and tell you that your quote firm, the public defender's office, has. And so that whole thing, and we all know, and I'm not lecturing you because you're in the legal field, but we all know that sometimes defense attorneys and sometimes judges and sometimes even prosecutors love to string things out. And this has been going on for 3 years and 4 months, homicide trial. And we do not have the same degree of proof that's required for us that the criminal system has. All we have to find is a preponderance. And so I think after 3.5 years, we delayed this thing long enough. My vote today, I don't know about the rest of the panel, my vote will be to continue it. But I can't suggest to the district court or suggest to your office, but I would just say that my patience on a 3.5-year-old homicide case is pretty worn out, but that's all I'll say. And I'll turn it over to my board for any questions. I don't see any need until we get this resolved about whether we continue it or not. We don't need to continue with this hearing. So I'll turn it over to the chairman to determine if he wants to poll the rest of the board.
Okay, Ms. Ledoux?
In the interest of justice, my vote is to continue this case, and I would hope that it would come before the legal system sooner rather than later.
Your vote is to continue it now?
Yes, it is.
Okay, my vote
today.
also continue.
Okay, and my vote also is to continue. So, Mr. Wilson, I hope I wasn't trying to be rude to you. I was just trying to be emphatic.
I appreciate that, and quite frankly, the next date that is given to Mr. Clay, we will have everything ready. I can also tell the board that he has a trial date that is currently scheduled for October 26th of this year.
Okay, thank you, sir. We appreciate you and what you do.
I appreciate that. Thank you. Take care, Mr. Clay.
This concludes our business at Orleans Parish today. We're
Hall, 26 CR 0014, you are Todd Hall.
Yes, sir.
Born in 1974.
Yes, sir.
Last 4 digits 700.
Yes.
You're Samir Porter.
Yes, sir.
This is 26 CR 0015. Mr. Porter was born in 1963.
Yes.
Last 4 digits so. You have a waiver of your representation?
Yes, that's already been done.
Both of you understand that you sign a waiver and you don't object to Mr. Cost representing both of you, even though there might ultimately be a conflict. If there is, you'll have to. What's the combo? Y'all move over here. Y'all move on over here.
Your Honor, I'm a victim on this case, received additional evidence. There's additional charges against Mr. Porter going to the grand jury today. Once that's taken care of, if he's arraigned next month, then we can get a pretrial, one more pretrial, and if we can't resolve the case, then I'll.
Let's go ahead and put a negotiation day next month, and you hand the information to him when it comes out today. Now, since he's already before the court, I'll have a summons issued instead of an additional warrant.
It's fine, sir.
That way you don't get arrested. September the 10th would be negotiation day, and
August 28th. Negotiation.
August the 28th is the negotiation day. September
I
10th. The next
know I'll be out the 28th, but I'll make arrangements with Mr. Stockton to meet with him prior to that
Make
day.
sure they're there.
Yeah, we will, and we'll need to make wait on this one.
Great.
Okay, Your Honor, I note that Mr. Porter has got another indictment for another possession of firearm by a convicted felon. If that should be processed as a summons and keep the same bond.
Are you talking about the one that's going in front of the grand jury
Yes.
today? How would you know about that?
Because Mr. Stockton and I have talked about it.
Okay, I don't know. What, Mr. Stockton, come on, you move over this way. Tell me about the firearm situation.
You've got the underlying case where Mr. Porter is accused of discharging a firearm near Mr. Doty, which caused injuries to his ear. And Mr. Porter denies having a gun and everything, so Mr. Doty furnished me proof before they were out target shooting. And Mr. Porter was firing with like a, I don't know, 38 or 45 caliber pistol. So, that's what we have. I think it's 45, Mr. Doty told me. So we're going back to the grand jury and indicting based on those videos, him firing the weapon and being a convicted felon here in Clinton County. And then I want to decide which of these cases I want to try. I probably have to give 404B notice on one of them. That's correct, Your Honor.
You know how I feel about firearms.
Well, I know, Your Honor.
That's the reason I'll go ahead and have him arrested. We'll take a look at this thing. So he can just be prepared to turn himself in. Couple things I don't tolerate. It's this firearms thing. But I'll take a look at it and have him evaluated by the pretrial.
I know he has very, very substantial bond over the postage.
Well, I'll take a look at that.
Thank you.
Christopher Hayes, Mr. Raymond. Hasn't been indicted yet. Since he's died, Are you Christopher Hayes? Yes, sir. Good morning. Good morning. This is 21 CR 0002. Mr. Hayes, were you born in 1992? Yes, sir. Last 4. Yes, sir. For the purpose of writing, if you have an attorney with you? No, sir. Can you afford an attorney? Yes, sir. You can. Well, I'm just going to go ahead and have the public defender step in for the purpose of arraignment.
I was sent there by Mr. Richard Armstrong.
I'm going to arraign you here, and then you can say what you want to say after you talk to an attorney. The grand jury of Clinton County has returned an indictment charging you with receiving stolen property. You understand what the charge is? You acknowledge the identity of your client for the purpose of arraignment. Receive an indictment, waive formal reading arraignment, enter plea of not guilty.
Yes, Judge.
Okay. Now, this gentleman has approached my staff lawyer earlier saying that, pretrial saying something about the involvement of a former county judge. I don't know anything about that. I don't know anything about it, and I don't want you to say anything else about it because it might incriminate you. Okay. Now,
Well, he's reached out to me too, and I'd like Mr. Hayes made bond, and I need to go back and review the files and see if you got a legitimate defense, and then we can work through it.
Okay,
That's good.
negotiation day on August 28th, be here at 9 a.m. Okay. And the next court date is September 10th.
So are we appointed on this?
Well, no, he said he did. He said he could afford a lawyer.
Okay. Right.
Okay, so you just give him the indictment and you're relieved of any further responsibility. You have a lawyer with you or here and be here on the 28th of August for negotiations. Okay.
Thank you.
Yeah. Darryl Halsenbeck.
My understanding, Your Honor, he's in custody in Alabama, and we're working on that and getting him up there.
Payroll City, this show was finished though. Hey, you put a NCIC or warrant out for Mr. Halsenbeck.
Yeah, we've
Tyler Ledbetter. Tyler Ledbetter. Are you Tyler Ledbetter?
Yeah.
Good morning. This is 26 CR 0049. Mr. Ledbetter, were you born in 1991?
Yeah.
Last 4 digits. It's a pretrial conference.
Judge, Mr. Ledbetter has a co-defendant, Terry Brett, as you'll see later at the docket. I've submitted a conflict request with Mr. Ledbetter. I kept Mr. Brett because he was in custody. And as of today, I know we've tried, we don't have anybody, and they're probably going to have to go through the process of getting another DPA office, I guess, on this. I don't know.
What's the charge?
Theft by unlawful taking. Allegedly, he and Mr. Brett took over $60,000 worth of stuff from across industries. I know this case has been lingering for a few months. I hope the EPA will give it some priority so we can move the case.
I don't really know what to do. It's not your fault.
No, I'm not fussing on Mr. Brett.
I know, but I'm just saying, I don't know what to do. I mean,
Well, we've managed to find something for everybody else. I think we'll
have somebody there with him on negotiation day on, the 28th of August here at 9 a.m., here at 9 a.m. But before then, you make sure you give them a good phone number that a new lawyer can get a hold of you and help you prepare for your defense, okay? September 10th is your trial date. August 28th is a negotiation date. Both of those are conditioned to your bond.
use the phone number still, sign this what you get. Okay.
Do you have a cell phone?
Yeah, he's already provided us with
Okay,
a number.
okay, thank you very much. Michael McLaughlin.
All right, so Gigi just said in the chat this judge should be retiring soon. Well, I looked it up. He's 73 years old, but unlike so many other states, Kentucky does not have a mandatory retirement age for their judges. So as long as he sees fit and as long as there's no procedure done to remove him and as long as he wins elections, he's on the bench. All right, friends, let's go back to Louisiana. We'll do one more with the board to finish out the day.
Colleagues are on Zoom, Ms. Jerry Ledoux and Mr. Steve Prater. We're at Ascension Parish Jail. Would you state your name and DOC number for the record, please?
My name is Shannon Lane. My DOC number is 331537.
Is there any staff in there with you?
Yes, sir.
State their name for the record, please.
Captain Sean Winchester with Ascension Parish Sheriff Office.
Thank you so much. Mr. Shannon, I'm handling your case today, and I'll be reading some violations. I'm sorry, do you have a questionnaire with you?
Sir?
You have a questionnaire with you?
No.
Can you put it up? All right, we're going to put it up. Did you sign this?
Yes, sir.
You're not eligible for an attorney. Do you want to get an attorney yourself?
No, sir.
Okay, you want to continue with this case?
Yes, sir.
Okay, thank you.
You're welcome.
I'm read some violations, and you can answer guilty, not guilty, or with a statement.
Okay.
Violation number 4, you fail to refrain from engaging in criminal activity as evident by your arrest on or about 4/5/26. You were arrested by the Gonzales Police Department for disturbing the peace, acting in a violent and turbulent manner, and aggressive assault on 6/16/26. Upon motion of the state, nolle pros was entered to assault aggravated. Accused entered a plea of guilty as charged to District Peace Violation Act. Court sentenced accused as followed: to be committed to the parish prison and serve 90 days credit for their time served. Sentences to run concurrent with the parole hold. How do you plead? Guilty, not guilty, or with the statement?
That's with the serving of peace.
Yes.
Okay, cause they dropped the aggravated assault.
So how do you plead?
I plead guilt on the disturbing the peace.
Okay. And violation number 10, you failed to make supervisional payments to the officer and probation and parole. You're currently $1,197 in the rear. How do you plead?
I plead guilty.
Okay. Do my colleagues have any questions they want to ask Ms. Ledoux?
I note that, Mr. Lane, you've had significant substance abuse issues since you were released. You were positive on several occasions for meth, cocaine. And so are you having some drug issues?
Yes, ma'am. I had wanted to go back to the Grove because I feel like I had missed something. It's a 28-day program, and I feel like I had missed something. And I like to complete. I like to go back and go back through it.
Okay. Well, I just wanted to address your substance abuse issue. That's all.
Mr. Prater, do you have any questions?
Will the Grove take you back?
Yes, sir. I can go admit myself. They'll take me back because I know the person who over it, and I know he'll welcome me back.
Do you think maybe a longer term treatment may help?
This ain't the long. I just figure I missed something by me, rushing to get out there. So I'll go back through it again. I know I'll get it right this time. Yeah.
Well, excuse me, Miss Ledoux, were you through? You're on parole for third offense DWI and drug charges, and then you get out and you get on drug charges. You go to rehab, you get in trouble, and you leave there, and now you want to go back and finish up the program, what you missed on it. I'm afraid you need I don't want to see you locked up, but I want to see you mandated to get the help you need rather than voluntarily, because I don't think voluntarily you're strong enough on your own yet. But that's just my feelings. I'll leave it up to whomever's on the board that gets to vote.
Okay. Are we prepared to vote?
Yes, sir, I am.
Okay, my vote, since I have your case today, I find you in violations of violation number 4 and number 10. I think you need to get some long-term treatment because what you're doing now is not helping you at all. So that's my vote. Miss Liz.
My vote is to, in lieu of revocation, to send him to long-term substance abuse treatment within the confines of the Department of Correction.
Mr. Prater?
I concur with that. In lieu of revocation, long-term substance abuse with DOC.
Thank you. Mr. Lane, you have been in lieu of revocation, is that correct? Yes. You will be sentenced to, I think it's a year drug rehabilitation. This will include our work here today. We're signing out at 9:25 at the Ascension Parish Jail. Thank you. Good luck, sir.
All right, friends, that will do it for this morning, but we will be back in 2.5 hours for second session, 2:30 p.m. Eastern, 11:30 a.m. Pacific. I do have that linked up, so when I end the stream, it'll send you over there so you can set your reminders. I've got a good lineup there today for you, including a person who stole the identity of not 1, not 2, but 3 of his siblings. So definitely tune in for that. Again, 2:30 p.m. Eastern, 11:30 a.m. Pacific. We've got Sidebar tonight, 8 p.m. Eastern, 5 p.m. Pacific. Join us for that, and we'll be back tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific for this show. Basically, at this point, I should probably just turn on the camera and run it 24/7. All right, friends, go have yourselves a good day, and I hope to see you in a couple hours. Take care. God bless.